This portion of the meeting is the general meeting agenda. We're not going to hear any testimony during this portion of the meeting, but if you need to have a conversation, please do so out in the lobby. So we're just going to do some administrative tasks, and y'all can hang out until we start the docket. All right, so I guess we're going to be recording this part, which is fine. Okay, so we have an extension request, 2 reconsiderations, a bunch of resolutions to approve. Not that I want a round of applause for writing all those resolutions, but I did really work really hard on that. And then a discussion about alley and footway appeals that are kind of pending right now. There's a bit of echo with the microphone, apologies. I don't know if there's anything I can do about that. Okay, so let's start at the top with the extension requests. Hi, Justin. Okay, so this is the BMZ 2020-197. So these documents are in tab 5 of your binder relating to the general meeting stuff. So as far as I can tell from what Mr. Berry has submitted, this was approved January 4th, 2021. We haven't received any extension request on this appeal until today. Well, until December 5th, I guess. So the approval under the law would have expired January 4th of 2022. We received the extension request December 5th, 2022. We have a couple of emails that say that the permit was filed and caught up in the permit system. We have a screenshot from the permit system that Mr. Berry submitted. So I think the law says that the permit has to be issued, or you have to apply for an extension within the 12 months after the approval is issued. But it's up to the board to decide whether or not to approve the extension.
So how did the permit section affect this?
All I have is what's been submitted to me. I didn't ask for more than what was submitted. So I think what the email said, a building permit was filed within 4 months of the board's approval. So that would have been like around April 2021, and has been caught up in the permit system. That's all the information I have.
You don't know what that means?
I got that email this morning at 9 a.m. So no, I don't have any more information than that.
Question, did we ever get additional information at the hearing on motions for reconsideration?
I have not seen that. Normally we say that there's no testimony taken at this part of the hearing. If you, let me double check the rules.
The question is it caught up in the system because of the system, or caught up because of the applicant's lag of providing whatever documentation was needed? I'm sorry.
Can somebody close the door, please?
I'm so sorry.
Me too.
Now we hear you.
You sure?
Thank you.
That's it.
Hello?
No, I don't think that there is anything in the board's rules prohibiting hearing from the applicant.
Well, can we?
If that's the case, then if, I know Mr. Berry's here.
Could I also ask everyone in the back, if you want to have conversations, just open and close the door as much as you need to go out, but we can hear you, which means the mics can pick you up. And I have to have my mic on, they say.
If we could hear from the applicant's representative, just with regard to a little bit more background. One concern is, we are trying to be a little more careful to adhere to what the rules say. And if our rules say that the approval expired, then I think we would be without authority to grant a motion for reconsideration. Unless there's something that sort of trumps that. But if we could hear, Mr. Barry, if you have any information you can provide to us.
Don't say Trump's.
Please don't.
And he then should be sworn in if he's gonna.
Did I say that?
Could you raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give today will be the truth, the whole truth, and nothing but the truth, so help you? I do. Thank you.
So, the board here is.
Can you turn the mic on, please? Thank you. Just hit the, there you go.
Okay, the board, as you know, routinely grants extensions for properties that were approved many years before this one was approved. The applicant did file for building permit. It's been in the system with back and forth between comments from structural engineers and so forth. That's taken some time, and frankly, the city permit process is not as expeditious as it has been in the past. And so he's following through. My understanding from the structural engineer is that they're close to getting a permit, but this came up at the last minute that it was past the time and they needed an extension by the zoning board so that they could approve the permit.
But, Mr. Barry, were you involved in this?
I was not, I was involved with the original approval, zoning approval, but not with the follow-up building permit application. So I was told by the engineer that the last part of the permit is to have zoning approve it. When it gets to zoning, they say, well, it's past the time, they technically need an extension. This is not a case where the applicant hasn't done anything.
Understood, understood.
Was the original appeal a variance or conditional use or both? Do you
It's
know?
both.
Okay. Does the board need me to read the section of the code that talks about expiration and extension?
Yeah, go ahead.
Okay, so there's two different sections. The first one is 5-309. A variance lapses and becomes void 1 year from the date of its final approval unless substantial construction has occurred within that year. And then for conditional uses, a conditional use lapses and becomes void 1 year from the date of its final approval unless within that year a use permit has been obtained, the erection or alteration of the structure has lawfully begun, or the use has lawfully begun.
And just to clarify, the original idea was to have a conditional use for neighborhood commercial and apartments. And what's being done is the permitting is for the apartments. And it was a density variance, I believe, required.
So certainly no construction has occurred because we don't have the,
No, the only thing that I believe he received approval for, but I can't verify this at the moment, was the interior demolition work that was done in preparation for the building permit.
I think on the record, fortunately, I don't see that it meets the test. It meets the standard.
No, that's right.
So the variance expires on its own unless construction is that what it is? Yeah.
Unless substantial construction has occurred within that year.
Do we consider applying for a permit a part of construction? Could it be considered the most substantial part of the construction?
I don't think we do. So there's, on the conditional use though, it says, say it again.
Sure, for conditional,
The issue of, if the board would like, maybe you could postpone this, we can get the construction engineer in that can give you a little more detail on this. I thought it was.
I'm fine with that, you know, because frankly, we have to decide now based on what we know. I think we have to be guided by the.
Can we also decide not to hold the extra time that it'll take between them coming back
Sure.
against them, like it stops right now? Like
Right.
They applied for it now, not like in 3 weeks when they come back or
Right,
whatever.
or
generally, we go by when they filed it, so it would have been December 6th.
December 5th.
Okay.
That's fine. I would, if everybody's in agreement, I would
I'm good.
I'm fine with that.
postponing that request for motion consideration and.
All right, so we will provide that information, and you can either have additional testimony or questions, or
That'd
whatever
be
you
helpful.
decide. Hopefully you will. Thank you.
All right, thanks, Mr.
Thanks,
Mayor.
Al. Okay, moving on to the reconsideration requests. Those are in the same section, section 5 in your binder. The first one is also submitted by Al Barry, 901 South Elwood Street. So just to, I'll sum it up for you. this was heard back in 2021, and in the resolution, the board did not include a height, I believe it's a height conditional use for this project. Although in the plans, it does show that they would have needed one. And so they're asking now, since that was omitted from the resolution, that the board amend its resolution now, having left that out of the previous resolution. So we're changing our process significantly in 2023. We're going to require a very clear list of all the uses and variances that are being requested with each appeal. That has not always been the case. And in this case, I think plans were submitted and then the board staff kind of went through and tried to find all the variances that were involved here, and they missed one. But it was included in the plan that the board did approve. So the board on its own can amend its own resolution to reflect any kind of clerical errors under the board's rules. So they're asking us to do that.
Yeah, I'm good.
Yes.
Yeah, I'm agreeable to doing that, to amend it. There's no
Okay.
additional evidence that we need, it was all provided. And again, it won't be on us, it won't be on the board or the staff to run through and identify variances and conditional uses. So in the future, it'll be on the applicant, but it's one we didn't catch, so I think we grant that motion.
Okay,
Fine with that.
that sounded unanimous to me.
Yes.
Okay. And then the third it's the second reconsideration request is for 2022 362 58 35 Park Heights. I will kind of sum that one up as well. Okay, so we approved what was requested, which was a one-story addition. Following the hearing, the appellant changed their plans and now wish to construct a two-story addition. They hadn't finalized their design plans at the time of the hearing. The plans presented at the time, but this was only, the resolution was issued November 10th. So this was within the past 2 months or so. Let's see. The design change does not impact the variance amount, but the board's resolution does specifically say one-story addition. They're asking for reconsideration, basically, so that they can have 2 stories of the addition.
Okay, so one story was presented to us and it met all the criteria for approval, and we approved that. 2-story wasn't. So I think if the applicant wants to have a 2-story approval, I think we need to hold another hearing.
But would they have to file a new application? Is
Well,
this a
I don't know. It's-
reconsideration
so
or is this a new application?
I think, could we
change your
grant a reconsideration, hold a hearing on that here, hold a hearing on the motion, allow them to produce additional evidence, although we have a final ruling.
But how is it a reconsideration if they change their mind and want something different? I think that's a whole new application.
Or is it if a modification, we tend to do those before we enter, we
Yeah.
tend to do those before we enter
Yeah.
a final approval.
What do we have on rules of reconsideration?
Sure, so the rules are in section 1 of your binder, and it's under Rule G, clarification or reconsideration. And this is the part of the rule that I'm always reading out loud, and it's kind of a mouthful, so I'll do my best. A request to clarify or reconsider under this rule must articulate in sufficient written detail identifiable facts supporting the contention that the board's decision is the product of any one or several of the following: fraud, mistake, irregularity, inadvertence, surprise, clerical or typographical errors, or upon a showing of good cause as to the unavailability of evidence, the existence of newly discovered evidence, or other pertinent evidence not available or not presented to the board at the initial hearing.
This doesn't fit in there.
Not a single one of them.
This doesn't fit.
If you
This is
look,
essentially a new project.
if you look at the request, it says, basically, it cites the last part. Upon a showing of good cause as to the unavailability of evidence or other pertinent evidence not available or not presented to the board at the initial hearing. I think well, you all can decide, but
Just find a new floor or what?
Go ahead.
you all can decide what you think. Generally, we ask that new evidence be something that, for some good reason, couldn't be found before the hearing, or is newly discovered or something, not a change of mind, but.
Yeah, I mean, if the design plans aren't complete, you get an approval and then you want to build a new building.
It seems more like, more like they should ask for a postponement until they have found design plans.
Right, but we got that now, so,
Is this
I think they have to present a two-story building
In a new
in
application.
an application.
Yeah.
Yeah. Not new evidence.
Okay. Can I get a vote on that?
I am for it's a new application.
As am I.
Well, so it's a denial of the motion for reconsideration.
That too.
I'm a no on the motion, so denial.
I'm also a no.
I'm a no.
I'm a no.
Okay, great. So moving on, I think we might skip the alley and footway stuff for today since we're running a little bit behind, but I'll make sure to address that first thing in January with you all.
Sure.
And just go right to the resolutions, which
Actually, wouldn't this be a good thing to take up with Justin here?
the alley and footway stuff.
He can come back in January.
That's fine, hey, that's fine.
He's not busy. He can come back whenever we ask.
Means he has nothing to do, that's fine.
Deputy Mayor Economic Development is not busy.
Okay, so let's go through the resolutions, the draft resolutions, which are in tab 4. And there, like I said, there are a lot of them, so I'll try to move through them quickly. The first one, 2022-365. This was let's see, a request to use a dwelling as 4 dwelling units, requiring a minimum lot area variance. It was a very small variance, and the board ended up approving that because of the large size of the property, the very, very small size of the variance, and the uniqueness of that property. Any issues on that one?
None.
No.
Okay. Moving on to 2022-252, 2245 McElderry Street. This was a case with opposition, and it was to demolish a kind of derelict building and consolidate and build a new residential multifamily dwelling with 10 dwelling units. The board found that the lot shape was unique and therefore granted the variances involved here and had a few conditions. They said that you wanted them to find or to enter into a contract for parking for at least 5 parking spaces, and then there were a couple other conditions as well. Any issues with that one?
No.
Okay.
No.
2022-338, 526 South Chapelgate Lane. This was the large residential care facility that originally had opposition from a neighbor, but then they ended up working with him, and he ended up withdrawing that opposition at the following hearing. So the conditional use. Any issues with that one?
None.
Okay. 1415 Washington Boulevard, 2022-386. This was the expansion of an existing tavern to the 2nd floor. And we remember that that tiny zoning district of one property within a sea of residential, one commercial property within a sea of residential, that ended up being granted. Any issues there?
None.
1700 North Payson Street, 2022-320. This was to use the premises as a carry-out food shop, which is not allowed in the zoning district unless it's some kind of pre-existing non-conforming use, which was not the case here. So that was denied. Any issues there?
None.
All right. These next two were heard together. So 707 to 709 Druid Park Lake Drive and 701 Druid Park Lake Drive. So this is 2022-359 and 2022-403. Those were the two kind of medium-sized apartment buildings that were being redeveloped with additional units. And the board ended up approving the variances for both of those under the terms that they would meet with the community and come up with a sanitation plan that they would then submit to zoning administration. Any issues with those?
Nope.
Okay. The next four were also heard together, so I will read them together. This is 1210 South Highland, 1216 South Highland, 1214 South Highland, and 1212 South Highland. And those case numbers are 2022-391, 2022-396, 2022-397, and 2022-398. Those were all very similar, as you remember. The board approved the conditional uses as to height for all of them, denied the variances as to the additions for the ones that had proposed additions or rear garages. So those were partially approved and then partially denied. Any issues with those?
None.
Okay, we're getting there, you guys. Okay, we're up to December 6th now. 4630 Homer Avenue, this 2022-382. This was a case where the property owner was asking to convert a single-family dwelling to a multifamily dwelling, which is not allowed in that zoning district, which was R6. So the board denied that one. Any issue with that one?
No.
1639 North Broadway, 2022-262. This was the man who owned the property that was a funeral home on the first 2 floors, we found out, and then a dwelling unit on the top. He was asking to use it for 3 dwelling units, and so basically to subdivide the formerly commercial section of the property into 2 dwelling units, and the board approved that. Any issues with that one?
No.
And we can't approve the York Road case because Frank is not here, so we'll have to skip that one and come back to it in January. And the last one, 205 South Chapel Street, 2022-415. This was the very confusing situation where the appellant had applied for something in the past, gotten confused on the math, and then had to come back to us to ask us to increase the variance slightly, which the board then approved. Any issues on that one?
No.
All right, that's all of the resolutions I have.
Becky,
I will,
Ms.
yes.
Mudge, what's the status of the drive-through and the chicken
Popeyes.
place? Popeyes on York Road? Still operating?
So,
It's definitely still operating.
it's definitely still operating. There has been a new appeal submitted for that. So that will be scheduled, I think it's scheduled for January 17th. They're asking for the conditional use to be reinstated.
Even though they've been,
In terms of enforcement, I have no information on that because that's a DHCD
Could we get
issue.
some information on
I
that?
could try to, yeah.
and
I could.
is there a way a DHCD person could come to the meeting on the 17th?
I will ask,
Okay.
yeah.
Thank you.
Okay, that is it from me. Do you have anything to say?
Yeah, I guess, well, Mr. Chair, if you'd be willing to close the meeting briefly for personnel discussion. Maybe during that time, Ms. Witt could read out the postponements and everything else going on.
Okay,
Whatever that section is. for the,
all right, let
moving
me
to
pull
closed
it up.
session
Whatever,
Pursuant to,
whatever it is, I second it.
Wait, you guys,
Okay.
we gotta be more orderly about this. Okay. So, here, I'll just describe what you need to do and then you all can do it. So someone needs to make a motion to close the meeting under the provisions of, general provisions, article, section 3-305B1 in order to discuss the appointment, employment, et cetera, of an employee or other personnel matter. And then you need to take a vote, and then you can go.
all right, I move that we move to a closed session pursuant to Article Section 3-305B1 for the purpose of discussing and acting acting on a personnel matter.
Second,
I vote yes.
Any abstains or any nays? No. The motion carries. We move to closed session.
All right.
Give us a few minutes, folks. We'll be back. No.
Are we ready to go back on the record here? Yes. Okay. Good afternoon, everybody. It's a lot more people than I expected today for such a short docket. Welcome to the docket for the Board of Municipal and Zoning Appeals. My name is Becky Witt. I'm the Assistant Counsel to the BMZA, as well as currently the Acting Executive Director. From left to right up here, you have Leland Shelton, who's board member. James Fields is the chairman of the board. Bill Cunningham and Sabrina Johnson-Turner are also board members. Please silence your cell phones if you haven't already. If you need to have a private conversation with someone, please do so in the hallway or in the lobby. When it's your turn to speak, please identify yourself and spell your name for the court reporter and be sworn in to testify. If you haven't already signed in on the sign-in sheet over here to my left and you plan to speak today, please sign in now. The board's oral vote on your case today does not make the decision final. We're required to issue our decision in writing in a document called the resolution, which is a process that often takes several weeks. They need to be drafted and then reviewed and approved by the board. So we will send them to you when they are ready via email. If you're unhappy with the outcome of your case, you can request reconsideration of the board's decision within 10 days of the issuance of the resolution, and you also have the right to appeal the board's decision to the circuit court within 30 calendar days of the issuance of the resolution. And would you like me to go through the docket? Okay, sure. It's a short one, like I said. Okay, so just starting at the top here, 2021-127 is on the regular docket. 2022-3, oh. Do you have the docket handy? It's okay. Okay, that's okay. The first one is on the regular docket. Second one, 2022-313 is on consent. 2022-315 is on the regular docket. 2022-402 is postponed. 2022-404 is on the regular docket. 2022-413 is also postponed. 2022-414 is on the regular docket. Sorry, this one is slightly out of order. So 2022-406 is also on the regular docket. 2022-428 is on consent. 2022-429 is on consent. 2022-437 is on consent. 2022-441 is on the regular docket. And 2022-442 is on consent. I'll hand it over to you, Mr. Chair.
Good afternoon, everyone. Sorry for the delay. We had some other closed meeting business to take care of. But turning to these matters, we have the docket that's broken into two parts. One is the consent docket, one is the regular docket. The consent cases are those for which the board believes it has sufficient information to approve your appeal. So we will call your case, a shorter number than we used to, but we'll call your case, line up in the order that your case is called. We will hear reports from staff and planning. Ask you if you have anything else you'd like to add for the record. Hopefully you can all hear that. Everybody else can. And ask you if you'd like to add anything for the record, and then dispose of your case, which is a favorable disposition, which is an approval. But again, you'll have to wait for the written decision. We ask that, we explained that it's not final, but for purposes, all intents and purposes, it's a win. For those matters on the contested docket or the regular docket, just one caution about the opposition. To the extent there are multiple voices of opposition, just attend to what you hear for those that are speaking in opposition also before you speak, so that we're not duplicative or repetitive about the bases for the opposition. For example, if parking is a concern, we don't need 30 people to stand up and say, parking is a concern for me. With that caution, we'll, just ask that you govern yourselves regarding that and the efficient use of time. We ask that you not take any action towards your project or in furtherance of your project until you do receive your decision, your written decision, and certainly don't do any work in the Baltimore City without pulling the proper permits. With that, we'll call the consent cases, again, line up in the order in which they're called, and we will get to those. And once you're all lined up, we will have you all sworn in. With regard to the regular docket, we will have the parties sworn as those cases are called. Okay, so for the consent docket, we'll call case number 2022-313, 1730 Fleet Street, Kyle Vanille. Next consent case is 2022-428, 3442 Hickory Avenue, Vincent DiLorenzo. Then we have case number 2022-429, 3405 7 Mile Lane, Avram Zeisman. Case number 2022-437, 100 Light Street, David Karcheski and Caitlin Peach. Uh, 2022-441, 701 West Landvale, East Wing Architects.
Oh, that one has opposition, so that's regular docket.
Oh, I'm sorry.
I don't know
And
if I
that's what it says.
misspoke.
No, you were right.
Okay.
I skipped over it. I'm sorry. Case number 2022-442, 12 Elmwood Road, Gavin Laurel. And that is it for the consent docket. If we could have all these folks sworn.
Hi, if y'all could just raise your right hand, please. Thank you. Do you solemnly swear or affirm that the testimony you're about to give today will be the truth, the whole truth, and nothing but the truth, so help you?
I do.
Thank you.
Okay, case number 2022-313, 1730 Fleet Street, Kyle Vanille.
Yes, sir.
How are you, Mr. Vanille?
Doing well yourself?
All right, welcome. Doing well. This matter addresses variances to bulk I'm going to ask you to step up a little closer to the mic. Thank you. Addresses variance to bulk regulations to enclose the second floor existing porch 6 feet by 11 feet and construct 12-foot by 18-foot walkout deck in the rear of the second floor with a 6-foot high wood fence on the deck. Is that correct?
Correct.
All right. I hear from staff and planning.
I have one variance requested here, minimum rear yard setback 20 feet required, 0 proposed because it's a fence, so 20-foot variance is requested.
Thank you. Martin French for the Baltimore City Planning Department. Planning Department has reviewed this application, noted that this property is in the Fells Point Local Historic District. The applicant received an authorization to proceed from the Commission for Historical and Architectural Preservation on November the 12th. And the department therefore recommends approval of the application, subject to the condition that all exterior changes, including additions, demolitions, and alterations, are completed in accordance with the authorization to proceed issued by the Commission for Historical and Architectural Preservation, dated November 14th, 2022. Thank you.
Thank you, Mr. French. Mr. Vanille, are those conditions to proceed according to chat acceptable to you or your client?
Yes.
All right. Is there anything else you'd like to add for the record?
No.
All right. Board, having heard your appeal, we believe you have sufficient information to approve your appeal. Thank you so much.
Thanks.
Case number 2022-428, 3442 Hickory Avenue. Vincent DiLorenzo is the applicant. Are you Mr. DiLorenzo?
I am.
Oh, welcome, sir. This matter addresses variances of bulk regulations to construct a one-story rear addition. Is that correct?
It is, but there's an important thing I should note. I think there's a typo in the notification, all the documents submitted. The correct property address is 3342 Hickory Ave, not 3442.
It's 3342.
Correct.
Okay. Make that correction. All right, is that the only change or addition?
Yes, sir.
Okay. All right, I'll hear from staff and planning.
As long as the notice sign was posted on the right property, then we're fine.
Was this, hold on. Was the sign posted on 3342
It is.
Free Avenue? All right,
Okay, great.
very well.
So 2 variances requested here, minimum interior side yard, 10 feet required, 2 feet proposed, so it's an 8-foot variance, and a minimum rear side yard, 25 feet required, 11 feet, 3 inches proposed, so it'd be a 13-foot, 9-inch variance requested.
And the planning department has no comment on this application. Thank you.
Thank you, Mr. French. Mr. Di Lorenzo, is there anything you'd like to add to your application at this time, sir?
Yes, sir.
All right. The board having heard your appeal, we believe we have sufficient information to approve your appeal. Thank you.
Thank you.
Case number 2022-429, 3405 7 Mile Lane. The appellant is Avram Zeisman. And we have today,
Hi, Drew Tilden, Rosenberg, Martin, Greenberg, on behalf of the applicant.
welcome. This matter addresses variance to bulk regulations to construct a 2-story rear addition, correct?
Correct.
Okay. I'll hear from staff and planning.
So there's 2 rear yard setbacks here, one for the deck, one for the addition. 30 feet is required in the zoning district. 5 feet 3 inches is proposed for the addition, 7 feet 3 inches proposed for the deck, according to what I have in my notes here. So there would be 2 different rear yard setbacks being requested here.
Planning department has no comment on this application. Thank you.
Okay. Anything else you'd like to add to your application today?
Yeah, I want to clarify that it's 8.5 feet, but otherwise, that's everything that I have.
Okay, the 8.5 feet goes to what measure?
So it goes to the lower measure. I think that was 5.3 feet that you had.
Okay,
And then I also want to clarify that the deck, since it's so much farther within the setback, it's just the 8.5 feet that we're requesting.
okay. Good with that, Ms. Witt? All right. Okay. If there's nothing else, then the board having heard your appeal, we believe we have sufficient information to approve your appeal.
All right, thanks so
Thank you.
much.
Case number 2022-437, 100 Light Street. David Karczewski. Good afternoon, sir.
Good afternoon, Mr. Chairman.
All right. This is a request to install multiple wall and freestanding signs, correct?
Correct.
Okay. Hear from staff and planning?
So there are several variances being requested here, all related to sign area. So the signs are much larger than, or larger, I'll say, than what's allowed by right. I don't know if I need to read all of these into the record. Would you like me to? It's kind of a mouthful, but I can do that if that would make the record clear.
We're all for clarity of record, so.
Okay. All right. So, and Mr. Karczewski can correct me if any of these are incorrect the way I'm reading them. So there's a proposed freestanding pylon sign, a variance of 1 foot 2 inches to allow a maximum height of 21 feet 2 inches, a variance of 5 feet 3 inches to allow a maximum sign width of 11 feet 3 inches, and a variance of 427 square feet to allow a maximum sign area of 477 square feet. That's the first one. Second one, sign area variance of 41 square feet to allow 2 wall signs on the ground floor to be located on the east and west facades of the existing building. The third variance is a sign area variance of 1,899 square feet to allow a 2,587 square foot wall sign on the east side of the existing building. The fourth variance, sign area variance of 1,608 square feet to allow a 2,120 square foot wall sign on the south side of the existing building, and a cumulative sign area variance of 4,248 square feet to allow a maximum cumulative sign area for all the proposed signs of 5,448 square feet. There are several letters of support in the file, including one from Downtown Partnership and Councilman Eric Costello. I think there are a couple other ones as well. And no opposition, obviously.
Thank you.
Planning Department has reviewed this application, notes this property is in the Inner Harbor Project 1 Urban Renewal Plan area. That plan requires that plans and elevations for all advertising, directional, or identification signs visible from any public right-of-way, park, pedestrian access facility, or boulevard be approved by the City of Baltimore. The review of the plans and elevations is to be concerned with size, design, illumination, location, materials, color, method of installation, and other factors considered appropriate by the city agency administering the plan. In this case, the city administering agency is the Department of Planning. The Department of Planning recommends approval of the application, subject to the condition that all signs, building-mounted or freestanding, are installed in accordance with designs and specifications approved by the Department of Planning. Thank you.
Okay. Sir, are those conditions acceptable to your client?
Yes, they are, Mr. Chairman.
All right. Is there anything else you'd like to add to your application at this time?
No, thank you.
Very well. The board having heard your appeal, we believe we have sufficient information to approve your appeal.
Thank you. Have a nice
Thanks
day.
so much. Take care, sir. Okay. Case number 2022-442, 12 Elmwood Road. Gavin Laurel?
Yes, sir.
Is that you, sir?
Yes.
All right, welcome. This matter addresses a variance to bulk regulations to enclose portion of a porch. Is that correct?
Yes.
All right, I'll hear from staff and planning.
So there's one variance needed here, a minimum interior side yard variance. 10 feet is required, 6 feet is proposed, would be a 4-foot variance.
Planning Department has no comment on this application. Thank you.
Thanks, sir. Mr. Laurel, is there anything you'd like to add to your application at this time?
No, sir.
All right, the board having heard your appeal, we believe we have sufficient information to approve your appeal. Thank you so much.
Thank you.
All right, good luck. Okay, we can turn our attention to the regular docket. And first case up on the regular docket is case number 2021-127, 2507 North Howard Street. Caroline Hecker is the appellant.
Good afternoon, Caroline Hecker, Rosenberg, Martin, Greenberg, on behalf of the applicant. I'm joined by my colleague Drew Tilden, and Matt Pinto from Seawall Development is here as well.
Okay. Ms. Hecker, this matter seeks to demolish the existing structure and construct a new structure with 64 dwelling units and approximately 25,000 square feet of office and retail space with a variance required to maximum lot area. Is that correct? Or may
Yeah,
be required?
yes, the variance may be required. We don't believe it is, but I'll get into that in more detail.
Very well. Okay, I'll hear from staff and planning.
Okay, so the board already heard this, in case this sounds a little bit familiar, and approved maximum building height and interior side yard variances in a resolution that was dated October 11th. There was a reconsideration motion filed, and the board agreed that we would hear more about maximum lot size, which was not, the variance was not requested in that application that was submitted before, that the board considered before. So the variance before you is maximum lot size. We don't see a lot of maximum lot size variances. We see a lot of minimum lot size. But anyway, 10,000 square feet is allowed. 42,384 square feet exists, so it'd be a 384 square foot variance requested.
Planning Department reviewed this application, noted that a portion of this property is located within the Charles 25th Urban Renewal Plan area. The Urban Renewal Plan does not restrict or limit the plans as proposed by the application. The department is recommending that approval of this application be subject to the condition that all improvements and alterations on the property are constructed and maintained in accordance with development and landscaping plans approved by the Department of Planning. Thank you.
Thank you, Mr. French. So do we have, Ms. Floyd, are you going to be speaking in this matter? Okay, could you stand and we'll have you sworn? Is anyone else here for case number 2021-127, 2507 North Howard Street? So you could swear the witnesses, please.
Raise your right hand. Thank you. Do you solemnly swear or affirm that the testimony you're about to give today will be the truth, the whole truth, and nothing but the truth, so help you? Yes, I do. Thank you.
Okay. Ms. Hecker.
Thank you. As Ms. Witt indicated, the procedural posture of this is a little bit unusual. We were here for a hearing at the end of August, and the board approved variances for setbacks and for building height. And at that hearing, we explained everything about the project, and there was no discussion at that time about this concept of maximum lot area, which is a bulk regulation that you find only in the C1 zoning district. After the initial hearing and after the board rendered its written decision approving the requested variances, Ms. Floyd filed a motion for reconsideration asking the board to revisit this area of maximum lot area variance. And I just want to state preliminarily at the beginning here that we believe that that argument was waived. There was a very full hearing on this matter at the end of August at which all of the bulk regulations for the project were at issue. No one at that time raised the issue of maximum lot area, whether a variance was required or not. We didn't bring it up because we didn't think we needed the maximum lot area variance, much like there was no discussion of density. There are 64 dwelling units proposed at this in this project, and we didn't make any arguments really about density at that hearing because we weren't seeking a density variance. Likewise, we weren't seeking a maximum lot area variance, so it didn't come up, but it's not something that was unknowable at that hearing or that there was any mistake or inadvertence or certainly not any fraud as alleged by Ms. Floyd in her papers that we were trying to mislead the board in any way about a maximum lot area variance being required. We don't think a maximum lot area variance is required in this case. I think respectfully that the way that the staff may be reading the regulation is maybe not quite the way it was originally intended. I'm quoting from the zoning code that the C1 neighborhood business zoning district is intended for areas of commercial clusters or pedestrian-oriented corridors of commercial uses that serve the immediate neighborhood. The C1 district is designed for very small scale, pedestrian-oriented, neighborhood-type commercial uses. It's not intended for large scale, big box stores, for example. And for that reason, in the C1 districts, there is this maximum lot area requirement. And what it means, it doesn't refer to the maximum area of the lot. It refers to the maximum area on the lot that a use can occupy. And that's why when you read the regulation, it's broken down by use. And it says, within the maximum lot area in the table and in the folder that Ms. Tilden handed out, you'll see there's an excerpt from the zoning code that restaurants have no maximum lot area. Food stores are limited to 20,000 square feet, and all other uses are limited to 10,000 square feet. It's a use-specific requirement. It doesn't relate to the size of the lot as a whole. Again, it relates to the size of the use on the lot. And the idea is to have small-scale, neighborhood-oriented, pedestrian-scale uses within the C1 district. And this is supported by the legislative history of Transform Baltimore. We've included in the file that we've handed out an excerpt from the third reader of the Transform Baltimore bill, which was enacted by the City Council. This is the version that was actually enacted. And if you look at the maximum lot area line on the table, it makes two things very clear. One is that it applies only to non-residential uses. It doesn't apply to residential uses. And for that, you have the minimum lot area requirement. That's what controls density. And also, it's described as being per establishment. It's 10,000 square feet per establishment or 20,000 square feet per establishment. For whatever reason, when it ultimately got codified into Article 32 in the zoning code, you'll see an excerpt from the code is attached here. The per establishment language got dropped for some reason, and I can't explain it, and it doesn't reference anything about non-residential uses, but the chart that's in the file is the version that was actually enacted by the City Council. So I think the intent is clear that it was intended to apply, first of all, to non-residential uses only, and also to the specific use on the lot, not the size of the lot as a whole. This was my suspicion, and so I asked the kind folks in the planning department if they could use their GIS system to figure out for me how many lots in the C1 district this would apply to. And I included in the file a printout that I got from the planning department of 362 properties that are larger than 10,000 square feet in the C1 zoning district. If this provision was interpreted to require that the maximum lot area in the C1 district could be no more than 20,000 square feet for a grocery store or for 10,000 square feet for any other use, any of these 362 lots would require a variance to have any other type of use on them. And that can't possibly have been the intent of the code. And when I looked further at it, Of these 362 properties, 91 of them have been granted use permits since Transform Baltimore was adopted without the need for any kind of variance relating to maximum lot area. And of those 91 use permits, 17 of them came before the zoning board. And so the zoning board has considered this in many cases and not determined that a maximum lot area variance is required. In the interest of full disclosure, I did include the only one zoning board decision we were able to find where a maximum lot area variance was granted. It was related to some properties in the 700 block of West Pratt Street, and the maximum lot area variance is granted without any substantive discussion of what is being approved or why a variance is necessary. I also included in the file a copy of the Planning Department staff report that discusses that application, which also does not address this question of maximum lot area variance. I think, I'm speculating, I wasn't involved in this case, but I suspect what happened is that an application for a project was before the board, and the board approved the whole project. It included whatever variances were applied for out of an abundance of caution, but there's no substantive discussion of a maximum lot area variance being required, although it was granted here. So, I think it's consistent with the way that the city has interpreted its own regulations to not require a maximum lot area variance for this. And similarly, in the case of this specific project, the decider in the first instance of whether a variance is required is the zoning administrator. And in this case, we filed our zoning application initially for the variance hearing that was held in August, and it was not processed or reviewed as needing a maximum lot area variance. And so when it got up to the zoning board, the intake sheet from the zoning administrator's office didn't reflect that a maximum lot area variance was necessary, because in their review of it, it wasn't necessary. And again, we had the hearing and the project, everything else was approved, but it didn't include a maximum lot area variance because we didn't believe, and the zoning administrator didn't believe it was necessary. Moreover, we're now in for building permits on this project, and the zoning office has signed off on the zoning approval for the project, again determining that a maximum lot area variance is not required in this instance. If they in reviewing the plans that have been submitted had determined that it didn't comply, that the lot was too big, then in that case, they would have said, no, we can't approve these plans. You have to go to the zoning board and get this approval. But that didn't occur here. So for all of those reasons, we don't think that a maximum lot area variance is required. But if the board disagrees, out of an abundance of caution, we posted the sign and applied in the alternative for a maximum lot area variance. And we believe that by nature of the unique conditions of the property, particularly its large size for the C1 district, a maximum lot area variance, if it's required, should be granted. The board, I would note, has already determined that the property is unique. In its decision dated October 11th, the board found that the property is unique and granted the other variances that were required. Specifically here, we have a property whose lot area is 42,384 square feet, according to the state records. The maximum lot area that would be permitted is 10,000 square feet for any other use besides a grocery store or a restaurant. Here we have some commercial uses and residential uses. I would note that none of our individual uses are greater than 10,000 square feet. The largest office tenant in the building is Wide Angle Youth Media. They're just over 9,000 square feet. It's about 9,100 square feet. So we believe the property is unique by virtue of its size, by virtue of its irregular shape. And the strict letter of the zoning requirement would require a variance if the lot was not permitted to be any larger than 10,000 square feet, if that maximum lot area requirement is a maximum lot area related to the size of the lot and not the use. These conditions are unique to this particular property. They're not generally applicable to other properties within the same zoning classification. The size of the lot is something that was created by the consolidation of parcels over time and existed prior to our client's acquisition of the property in 2014. It's not based exclusively on a desire to increase the income potential of the property. It would be required for any type of development on this property because of the size of the existing parcel. And the granting of a variance would not be injurious to the use and enjoyment of other property in the vicinity or substantially diminish or impair property values in the neighborhood. There are letters of support in the file from the Charles Village Civic Association and the Greater Remington Improvement Association. The project is a project that'll provide affordable housing and generate community service hours. It's a great project that the neighborhood wholeheartedly supports. And so we don't see it having any negative consequences or adverse effects. It is consistent with the purpose and intent of the zoning code by creating additional housing options for residents, and likewise is consistent with the city's master plan, as Mr. French mentioned. It's consistent with the urban renewal plan, and again, won't be detrimental to or endanger public health, safety, general welfare, or morals of the city, or be in any way contrary to the public interest. So for all of those reasons, we would request that the board find that a variance is appropriate and should be granted, should one be necessary. But again, we don't think that a maximum lot area variance is required in this case, because I believe that the interpretation of maximum lot area relates to the maximum area on a lot that a use can occupy, and not the size of the lot as a whole. So that was a lot. If you have any questions, I'm happy to answer them.
Thank you for that presentation and for the outline that you provided, which supports or parrots all of that. Any questions for Ms. Hecker at this time?
Not at this time.
Okay, all right, and we'll hear from Ms. Lloyd.
Thank you very much, and thank you for granting the reconsideration, so we could talk about this issue and address this issue, because it wasn't addressed at all in anything I could find in the previous hearing, including the materials that were submitted. So just when we were here in August, some things did not add up to me about this application, and in particular, including the fact that a massive new development like this one could be exempt from parking requirements, which we were told that the entire C1 zone is exempt from parking requirements. But what no one mentioned is the context of that exemption. It says in 10201 of the code that the C1 standards are designed for, quote, smaller commercial sites, end quote. So for me, that actually explains the parking exemption for the C1. It's not for large sites and large developments like this one, it's for smaller sites. That puts it into context when you read the sections together. But I'm not here today to talk about parking. That was just a way in. I'm here to talk about the regulations of the C1 zone as they are written, as they were enacted, and what they mean for this property. And I just heard an interesting theory from Ms. Hecker that what was actually enacted was something that's different than what's in the code right now. And that troubles me, because I can only deal with what's in the code right now. That's what I'm going to talk about today. The most basic and important thing that is about the C1 zone is this interesting thing called the maximum lot area. It is only for the C1 districts. The C1 zones have maximum lot areas for most uses, and those are found in Table 10-401. So the code doesn't just say the C1 zone is for smaller sites. Smaller sites are actually built into the regulations in this way. This property has been surrounded by smaller sites for as long as I've lived on the street, up the street, I should say, which is 27 years. Yes, I agree with maybe one little thing, maybe two things that Ms. Hecker says. The property is unusual in that respect. It is a large lot, a large site. It's not a small site. It's an anomaly in the C1 zone, which we've only had since 2017. It's not a variance issue that this is unusual or an anomaly. It's a nonconformity issue. I'm suggesting to you we're dealing with nonconformity. Since the maximum lot areas were imposed in 2017, the use of this property has been nonconforming because it had a commercial use on a lot that greatly exceeds the 10,000 square foot maximum. We just heard it might be 4 times that. But you know, 10,000 square feet is not tiny. You can do a lot with 10,000 square feet. Now, nonconformity has its own specific chapter or title in the code, an entire title about nonconformity. And I would suggest the most important part of it for this property and this application is the part that talks about abandonment under 18307B. In particular, abandonment by the removal of structures. What's being proposed here is demolition of the entire site, and as this board knows, that is the time when nonconformity comes to an end. When you demolish what's there, And that's exactly what the owners have decided to do. They're deciding to demolish what's there and start over. So what's built needs to conform to the regulations of the C1 code. So I don't believe you can approve this development on a lot of this size in the C1 zone. It's completely out of scale with the C1 zone regulations and the smaller C1 sites that surround it. So let's look at the C1 regulations, please, in Table 10401. I'd like you to look at these along with me. And in particular, two that go together are maximum lot area and maximum building height. Just a note about maximum building height here. Are they proposing a mixed-use development? Yes. Are they proposing a mixed-use development with dwelling above the ground floor, which would have a maximum building height of 60 feet? No. They're proposing a mixed-use development with dwellings above 2 floors of commercial. That's my understanding from the first hearing. That has a maximum building height of 40 feet. Remember, this is all about scale and smaller sites. That's what the C1 is for, smaller sites. So now let's look at this maximum lot area for just a second. The uses they're proposing have a maximum lot area of 10,000 square feet, which is greatly exceeded by this property. And it's not maximum use area, or maximum floor area, or any of those things. It's maximum lot area. That's where it is in the code. This lot is too large under the C1 regulations for the commercial or office use or retail use they're proposing. And according to what's in the code right now, it's also too large for the residential use they're proposing. So if you look at, and I did mention density previously. For the residential use, if you take 10,000 square feet maximum lot area and you divide that by the 300 square feet lot area per unit, the number of units intended for any one site in the C1 district is capped at 33, which is approximately half of what's proposed here. They're proposing about twice that. So again, what is being proposed here is massively out of scale with the intentions and the regulations for the C1 zone. The ones that are actually in the code, not ones that somebody says was enacted but somehow didn't make it into the code. So the code requires this property's nonconformity with the C1 to end with the demolition of the existing structures. It's not about trying to reuse something that exists or come back within 12 months or whatever. This is demolishing the existing structure, clearing this property, clearing the site. And in this case, after that, conformity has to be established. This property does not qualify to be redeveloped as a large site in the C1 zone. So my statement is that the owners need to go back to the drawing board, literally back to the drawing board. They should divide the site, which they know how to do, they can do it, it can be done. And again, 10,000 square feet is still quite significant. They should develop the new smaller lots in a way that conforms to the C1 zone regulations for smaller sites with heights no more than 40 feet unless they're building one of the specific uses that allows for 60 feet in that C1 zone on that chart. And also, let me just suggest something that what they proposed is a little more like what might be happening in a C2 zone. And this is simply not a C2 property. It's not, it's a C1 property. And I think to treat it as such, to treat it as a C2 property by this board would be to effectively rezone it administratively without sending it to the city council. If they want C2, they have to go to the city council. I also believe if they want the code to read other than what it says, they need to go back to the city council and ask them to amend that or clarify that or whatever it is. Because what I'm seeing is the same thing that you're seeing is what is actually in the code right now. And it's for smaller sites. It makes sense. Makes a lot of sense. So that was what I wanted to say to you all today, and I really appreciate the opportunity.
Thank you so much, Ms. Floyd. Any questions for Ms. Floyd in her presentation at this point?
I have a question for staff.
Do we have a city law department weighing in on this issue?
No, we do not. I could request some feedback from the law department?
Hold on. Okay, I'm sorry. I heard a game or something being played. Okay, one, that was just a question of clarification that we don't have that. I think that might be something that we want to do. But at this point, is there anything else from you, Floyd?
Not unless you have questions, but I think that's a good idea.
Thank you.
Once again, to our staff, I mean, I agree with what he just said, but does our staff, our council have any comment on what was just presented? I mean, I know it's a lot to take in.
Let's do this. Let's let Ms. Floyd have a seat, and we'll hear from Ms. Hecker.
Yeah.
We can still take it out before.
I can maybe weigh in during deliberation.
Yeah.
Well, by all means, if you have an opinion, I'd love the opportunity to respond to it.
Go ahead, Ms. Hecker.
Just very briefly, I'm pleased that Ms. Floyd and I agree on one thing at least, which is that the property is unique and
Maybe two.
maybe two even, right. It is a large property in the C1 district. I will tell you that there are 362 other large properties in the C2 district, or the C1 district, that would be subject to the same requirement. I don't believe that the size of the lot is something that can be abandoned the way that she suggests. She talks about a non-conforming use being abandoned if the building is demolished. The size of the lot is the size of the lot. It can't be abandoned. The lot doesn't somehow magically become smaller if the building comes down. It's something that you're stuck with, and they would have to go through a process to subdivide the property, and I don't believe that that was the city council's intent in adopting a maximum lot area requirement. Again, I believe that that relates to the size of the use on the lot, the maximum area that an establishment or a use can occupy on a lot rather than the size of the lot itself, because certainly the city council didn't intend for 362 properties in the city to become essentially unusable without going through a variance process. For all of those reasons, if the board doesn't agree that the size of the lot is or that it relates to the size of the use on the lot, and I think if you think that the maximum lot area requirement relates to the size of the lot itself, then respectfully, I would request that you grant the variance to permit this development to proceed on a lot that exceeds 10,000 square feet in size. It's just over 42,000 square feet. So it is something that the board can approve by way of a variance. I would also say that while I certainly would always welcome the law department's opinion, this board is the body that is charged with interpreting the zoning code regulations, and I don't think you need the law department to offer an opinion, although certainly, like I said, I always welcome their views on the zoning code. And Ms. Witt, if you have other comments, I would certainly welcome them as well.
Thank you, Ms. Hecker.
Thank you.
Let me just say, sometimes we do depend on the law department because there's a lot to take in in a 10-minute, 15-minute shot, so.
You mentioned, well, the issue is whether we deliberate now or whether or not we would like the law department to weigh in on these issues of, among other things, legislative intent, which will either go to whether or not a variance is necessary, given the history of the C1, the creation of the C1 zoning district, which I think would be of some help and assistance to us if we were in a position to get an opinion or a city law department to weigh in on the issue and the issues raised by the opposition. We have that, we could have it available to us in time for us to deliberate at the next time we meet. Is that okay?
Sure,
In other words, a quick turnaround.
I think that should be fine. I mean, the next time we meet is January 17th, so I think that's plenty of time to get an email back from Adam is extremely responsive. This is the first time I'm seeing this chart of what was enacted during Transform, and it's interesting. It definitely doesn't match what is. I don't really understand. It provides some legislative intent, I guess.
Okay.
Or,
Well, then let's do that. If the board agrees that we would defer deliberation until we can at least receive an opinion or some insight and advice from the law department. And we would be inclined to take the deliberation up at the next time we meet on January 17.
Okay.
All right, thank you.
Thank you.
Okay, calling case number 2022-315, 4229 Pimlico Road. Melvin Kreider, the appellant.
Hello, how you doing?
How you doing?
How are you? Your name, ma'am?
Juanita Griffin?
Okay, are you here for the appellant?
Yes,
Okay. Ms. Griffin, this matter seeks to use the first floor of the premises as a convenience store, is that correct?
correct.
All right. Your name for the record, ma'am?
My name is Clara Bailey,
Okay, Ms. Bailey. B-A-I-L-Y or L-E-Y?
L-E-Y.
All right. Do we have folks here in opposition?
Yes.
Okay, I'm going to ask you all to stand so that you can all be sworn.
Over here, please raise your right hand. Thank you. You will all solemnly swear or affirm that the testimony you're about to give today will be the truth, the whole truth, and nothing but the truth, so help you? Yeah. Thank you.
Okay, I'll hear from staff and planning.
Okay, so there's one conditional use being requested here, retail sales through the neighborhood commercial establishment section of the code. If you recall, the board heard this case partially already. There was significant opposition to a corner store, convenience store at that hearing, and the board offered to the appellant that he could postpone the matter to discuss further with the community, which he agreed to do, and asked to reschedule the case. So we haven't heard any updates on whether any meeting has taken place or any kind of discussions that may have happened in the meantime.
When was it the first time?
September?
Okay.
Planning Department reviewed this application, notes this property is in the Park Heights Urban Renewal Plan area. The department notes that the urban renewal plan does not restrict or limit or prohibit the proposed use. Proposed use, in fact, was previously established on this property at one time, but it's no longer present. And that's the end of our comments. Thank you.
Thank you, Mr. French. Just a quick question. Ms. Witt, do your records reflect any requests that we get, any agency reports, either from the police department or anything like that?
I don't believe so.
All right. Ma'am, who wishes to present?
I'm here to speak on behalf of Ms. Jennifer. My name is Clara Bailey. We have done a study in that neighborhood where we have signatures of several people, residents that lives in that neighborhood. She's been living in this place for 2 years. The church now wants her to put a cafe in a convenience store, which she's not able to do at this time. They want her to put it in there as a nonprofit organization. All she wants is a convenience store.
Hold on 1 second, ma'am.
We did talk to the.
Hold on.
This feels like this is against this appeal.
No, she's speaking in favor.
Okay.
Okay.
Let me start this way. When we were here last, a postponement was requested and granted so that you could have some communication with the community.
Right.
Tell us about what's taken place between then and now.
We sat down with them. I went to few of their meetings, and
Who did you meet with?
Mr. Stevens and the church board.
Okay.
And we talked about having a cafe, which then after a while, once I went to that meeting to find out what did they want in the cafe or in the convenience store, they supposed to wrote it on some notes. So as the meeting was over, the notes supposed to came back, which only 2 notes came back, and it was just saying, had Wi-Fi for kids. So I was like, that was already in the plans to have Wi-Fi. I didn't talk to the police station for service. We didn't sat down with them. They didn't mind putting leaking into our security cameras in the store. And we was talking about lights out front.
Well, what's the import What's the result of that, talking about lights out?
Well, right now, everything's being processed. They agreed to all of that for the police to actually have connections to the cameras
Okay,
and the store.
cameras inside and outside?
Right, front and back,
Okay, lighting,
and front and back.
okay,
And it's a police camera right on the corner.
okay. And you indicated that what was communicated to you was, can you add Wi-Fi in the,
Right, but then when I had went to the, so, you finished? I didn't wanna-
go ahead, go ahead.
When I went to the second meeting, it was about, they wanted to run the cafe,
I'm sorry, they wanted to what?
run it. So they wanted me to lease it to them. And
The
I didn't.
community, I'm sorry, who wants to run it? The community, the church? Who?
Yes. Stephen and the church.
The church want her to put a cafe in there,
So that they don't-
nonprofit for them to do. But if you're going against a convenience store by saying, no, you don't want a convenience store, how you gonna get a cafe?
Okay.
The
Tell me
church has also an empty building. If they want a cafe, they could have been put their cafe in. This church been around for a while, ain't just come 2 years ago.
Give us one moment, please.
Sure. She's the owner.
We're off the record for a minute. Hold on. I don't know. They have it in a.
And that's the same as before, correct? It's the same application.
It's the same application,
Okay.
yeah.
Is a cafe considered retail sale?
Uh-huh.
I guess we're back on the record.
Yeah, let's go on the record. What we're, let's, we need to address this on the record.
Yeah.
We have a board member here who was not here.
Can you turn your mic on?
Was not here for the original presentation in September. And so some of that context that we already know, one of our board members doesn't have.
It's me.
We figured that
Okay.
The
out.
issue that it's raising is we need 4 board members to fully hear the matter. Either it would require and may contemplate.
Who was there when I wasn't here?
I don't know.
It was Frank.
Right, it was 4 people.
Hold on.
You have to be recognized by the chair and introduced, but
If your memory-
just hold on to your question for a second. We'll come back to you.
So Frank was here.
So we need to
Sabrina was
defer
not.
again when Frank is here.
Is that the rule?
I mean,
They can,
If she's here, we just,
we could just go over it
Yeah.
from the beginning.
unless I recuse myself, I never feel comfortable without all of the information. And if the 3 of them have something that I don't, which is context, I still think even if you go over it again, I'm still missing half of what happened. Unless you want me to watch the YouTube, is there a Charm City
There
video
should
I
be.
could watch or
Did we
something?
have that?
that's still available. We can,
I can look for that. I'll check right now.
we can postpone deliberation. It still allows Sabrina.
Yeah.
Time.
And
Acknowledged by the chair.
hold on, I'm not done.
I'm also not afforded the opportunity to be able to ask any questions of the,
Original.
yeah, if I watch the video and have questions, I won't know what to ask today before. I'm the person that recused himself the first 2 meetings because I wasn't sure I was able to hear everything fully. So this is not
No, it's not.
out of character for me.
I think you just have to, sorry. I think you just have to weigh, Sabrina, you're feeling comfortable about not having had the chance to ask questions in the past versus having to reschedule everybody again for when Frank can be here, which, I mean, is another whole thing for all of these people who have already come twice.
Don't put that on me.
Sorry.
Don't put that part on me. That should have been discussed when Frank was here, that if you were going to postpone it and table it, it needed to have been scheduled for when he was gonna be here, not for me on the back end.
If,
I'm also, I think I'm hearing it, this is a totally different concept than the original retail sales, because I keep hearing cafe,
I want convenience.
and excuse me, and I don't think they're the same.
well, the original application is for retail sales, which includes convenience store. It sounds like this applicant who's here today intends to move forward on retail sales, which is what she asked for.
Why are we listening to cafe?
I think that's because, and we can ask people for more context, but I think that the community had asked her instead for something different from what she asked for.
Yeah, I think she was telling us that the community, this is what she's proffered. The community wants a cafe, but they would, a nonprofit cafe. However, they would rather move forward with their original application, which was for neighborhood commercial establishment, corner store, convenience store, which I believe is what we just heard.
Okay. Hold your thought for a minute, where you are. Gentlemen, I'm going to recognize you. Come over to the podium so we can hear you. But if you can, limit it to the issue we had just been discussing.
Sure.
All right.
Good afternoon, everybody. Thank you, Mr. Chairman, for agreeing to hear me.
Your name?
I'm Stephen Johnson, sorry, President for the Pimlico Terrace Neighborhood Association.
Which neighborhood association?
Stephen Johnson, President for the Pimlico Terrace Neighborhood Association. Just wanted to ask, point of clarity, since the same individuals are here from the September hearing, could we provide Ms. Turner with the context so that way that she could have the same information as Mr. Frank did? Therefore, she's not out of the loop, and we could proceed since this is the second time that we're here and folks have made allotment to do so.
Sure. We can allow you to present what you need to present here.
Mr. Chairman, would it be okay if we allow this to continue to go on? They present, and if Sabrina, you don't feel comfortable
I'm telling you
with
right now.
voting,
I'm telling you
then
right
you
now.
just say.
I can tell you right now, it'll be
comfortable.
3 people voting. I'm not.
Not today, but even at a later date, maybe we could postpone it if you still have questions or feel uncomfortable.
But then it should be Frank watching this video and not me watching the first video.
Okay.
Or whatever. It's just.
Was there not an audio recording of the September
There's a
hearing?
recording. There's information that can be learned and heard. So the issue goes to deliberating on the matter, which in any particular case, you may not get a deliberation at the conclusion of your case for whatever reason.
Got you. Okay.
Go ahead and have a seat.
Yes, sir. Thank you.
We've heard that.
Well, I hear Sabrina saying that you don't want to go forward even if you can watch the hearing later and deliberate later.
Yes. Well, if it's me that's required to be the. This is going to happen again this summer anyways. I wish I had known this was on the docket today, so I could have watched the video before this meeting, and then I would be informed for what these people are all here to talk about, be able to ask my questions of them based on that and this, instead of sitting here today and listening to what everyone has to say, going back and watching the video, and then never being able to ask questions either from the first time or today. But I suppose that's a wish, so. What did you ask me again? What
Oh,
decision am I making?
it's just, it's up to your judgment, Sabrina. I don't think the law prohibits us from going forward and kind of rehearing the case. But it's up to how, it's up to you. So whatever you decide is fine. And I apologize for not giving the video ahead of time. I didn't realize that
This wasn't
this was
a repeat.
No, I certainly understand where you are, and that the record could possibly become deficient if you don't get the information that is necessary for you to properly render a ruling. What we, I guess, would like to avoid, if we can, is a third hearing, to bring everyone back, and/or to bring Frank back, to hear this. We need 4, we had 4.
So he had the opportunity the first time to ask questions of both sides, I guess, both sides.
Sure.
And if I recuse myself from this one today, and we let the sides still present their information, then he can watch that video and we can deliberate, you all can deliberate on that once he's had a chance to do that. And that's something that doesn't have to take place in this room because it's not something that everyone's involved in. So you guys could deliberate over Zoom, right? Do we have to deliberate like in public, like in front of everyone for every time, or?
It has to be a public meeting. It doesn't necessarily have to be,
Okay.
I mean, it could be a Zoom, but it would have to be posted and everything.
Okay.
Well, that also presents a similar problem for Frank,
He might not have the same
because
scruples as
he
me
won't be able to follow up with any pertinent questions.
today.
No,
Mr.
he
Chairman.
hears the testimony
Yeah, he won't be able to
from
ask
today.
questions of today. Yeah.
All right, so,
Question for the chairman, please.
yes, sir?
If I may ask, Ms. Turner, what context would you be missing in order not to be able to ask questions of both sides if the matter is represented and then we are presenting while we're back here today?
I don't think that's. an
Respectfully.
appropriate
I don't know how to,
question.
and also I don't know how to answer that question because I don't know what I don't know.
It's not an appropriate question. She's made her statement.
I just asking for clarity, as a layperson, not a part of the zoning board, that way I kind of have that information
My
as well.
short, I can give you a short answer.
Sure.
Is I don't know what I won't know. Like I won't, like, how can I tell you what I won't be able to ask if I don't know it? Yeah.
Even if the information is reintroduced and then we talk about why we're back here today, that's all I was asking.
I think I answered.
I think her position is, there's still a chance that what occurred at the last hearing, something will be missing, something will happen. There's questions that were asked and answered at the last hearing that she doesn't have access to today, and she would like to have access to that before deciding upon
Yeah, I mean,
today's.
ideally, obviously, we'd have everybody here who was here before.
Or I could have filled myself in
Or, yeah, we had a,
before I got here today.
yeah, we would know that, but that's not where we are, so. If there is a determination to recuse yourself from the hearing, that means we'd only be hearing testimony by 3 board members. Not just deliberations, but sort of recuse yourself from the
Yeah,
matter.
I don't ask anything. I'm not a part of this one. That just means it has to be unanimous, right?
No, you
Gotta
have to
have a
have
quorum.
4 board members to make a
Board
decision.
members to hear.
Do we need to have a quorum just to hear them out? And then when Frank comes, he'll say, hey, although I wasn't able to ask any questions at the last hearing, I've seen it. I can decide.
Yeah, is the
Yeah.
quorum for hearing it or for deciding it?
Oh, it's for here?
It's for making a decision.
Well, we can't have presentation to 3 board members.
I think that would be a bad precedent to set. I think the board has done it in the past, but I don't think it's a good practice. I mean, I could ask Roxana if she can call Frank to have him come here. I don't think that's likely to work since he has a busy schedule.
That's not an option.
No. I think you all have to,
Oh,
decide what to do. I know that the board has to have four members to make a decision, to take a vote.
I think it's clear that it has to be postponed, and this isn't the first time that parties have had to come back more than once, not since I've been on this board. And it's something that's not necessarily always foreseeable, but it's what happens when we don't have a full board of 5.
Well, here's where we are. So, formally, you recuse yourself from this matter.
Yes, sir.
All right, so if you have a recusal from a board member, that leaves us with 3. That's not a quorum of board members. And we can't hear that and then take action on that. It is obviously an extreme inconvenience. There are ways we could have avoided this, but we weren't able to do that. And so I apologize as a chair on behalf of the board. If we have a recusal of one member, we don't have those options of people agreeing to go before 3. It's a quorum is a quorum. It's a legal requirement that a certain number of board members hear your matter. So at this point, we are going to necessarily have to postpone hearing this.
And we can either reschedule it for when he is here, or I can watch the video. And then the next time we come back, I'll be brief. So either one of those 2 things. We don't have to wait for the next time Frank is here.
Yeah.
I just need to watch the first hearing.
And to your point, the critical information has to get to the persons reviewing the matter and deciding the matter. Ma'am?
I understand exactly what you're saying. I'm glad that you said what you said, that you don't feel comfortable with agreeing on something that you know nothing about. So therefore, I'm going to agree with you to you watch the video. But at the same time, I'm going to ask to be saying, this is about a convenience store.
Okay, hold on to your substantive arguments. We'll hear that when we can hear that. Is there such a thing as going off the record? Can we talk with you for a minute? That's all has to be on the record.
The board,
Yes.
it needs to be on the record unless we go to closed session.
Okay, the question is, if Sabrina recuses herself from hearing the matter, is that recusal for the matter generally, so that we need Frank as opposed to Sabrina?
I think she could just clarify what she meant, which is that she doesn't feel comfortable going forward today,
Okay, yeah.
but that she will watch the video and we will reschedule.
Because in the formal parlance, recusal means I
Yes.
cannot hear this matter, and I'm gone.
Right.
So we need someone else.
I'm
That's not what we
unrecusing
want.
myself, and then I'm just going to, for today, say that I cannot go forward and hear this case until I watch the first half of it. And after that, I will be actually unrecused. I don't know, but you all understand what I'm talking about. The important part is I'm not barring myself from hearing this case in its entirety, just doing it for today.
Thank you.
That's where we are. So again, I apologize to the parties, but if we don't have the 3 members hearing it and be in a position to hear it, we can't hear it. And so we will seek to put it back on as quickly as we can. Would that be the next
It could be January 17th, probably. Yes, we could put that on that, if that works for everybody, or the 31st. But we can follow up and figure out when the best hearing date would be.
Hopefully 17th.
17th. Okay, we'll follow up with you and get you back on the schedule. And I apologize for that.
I'd just like to say, I'm sure there's a lot of people in the room here that are really confused by what's going on. The zoning board is supposed to have 5 appointed members. Unfortunately, right now, we only have 4 appointed members. So we have a rotation of folks who sit in, if they can, to give us that 5th member.
Or sometimes
So-
a 4th.
So we know that this is really inconvenient, but it's out of our control. That's what I wanted to say. I'm sorry.
Thank you. We'll move on to the next matter. So, case number, whatever this is, 2022-315 will be postponed, and we will reconvene for another time. Thank you, sir. Appreciate your patience. Appreciate the patience of the rest of you as well. So we'll move on. Call the case number 2022-404, 719 North Point Road. Changing minds, touching hearts. The appellant. Is there anyone else here for this matter? 2022-402. We swear the witnesses, please.
Over here, raise your right hand, please. Do you solemnly swear or affirm that the testimony you're about to give today will be the truth, the whole truth, and nothing but the truth, so help you?
Yes.
Thank you.
Okay. This is a request to use the premises as an outpatient mental health clinic. Is that correct?
Yes.
All right, I'll hear from staff and planning.
Okay, so this is a conditional use requested, either as an office or healthcare clinic. Wasn't clear from the application. The issue here is that this is an I2 zoning district, an industrial zoning district. And so offices are allowed only as a secondary use to a primary industrial use on the same site. According to the planning department, there's no industrial use on the site. So without that primary industrial use on the site, offices are not an allowable use, and healthcare clinics are also not an allowable use in this industrial zoning district.
Planning Department reviewed this application. Note this property is in the I2 zoning district, as you heard. The property is currently used, according to records available to the department, as a motor vehicle dealership with outdoor vehicle display, which is a non-conforming use in the I2 district, not a permitted industrial use. Therefore, there's no primary industrial use to which the proposed office use could be considered secondary. And as noted also by your staff, the use of the property as a healthcare clinic is not an allowed use in the I2 zoning district. The department therefore recommends disapproval of the application because the proposed use is either prohibited if categorized as a healthcare clinic, or is prohibited because there is no primary industrial use of the property to which an alternative categorization of office use could be considered secondary according to the zoning codes table 11-301. Thank you.
Okay, your names?
My name Lamia Pratlow.
I'm sorry?
Lamia Pratlow.
You're gonna need to spell that for the
Lamia Lamia, and my last name is Pratlow, Pretlow.
ma'am.
I'm Courtney Hunter Sams, Kourtney, last name Hunter, hyphen SAMS, Sams.
Okay, so we've heard from staff and planning. I don't know if you were aware of this prior to today. Did you get that information as to what the prohibitions were in this zoning district?
No.
Okay.
The landlord that we're renting from just had mentioned that he thought it was a great asset to the community, but that there was no reason why he didn't understand why it was listed as a industrial use. We primarily are a community-based program, so all of our services are done in the community, in people's homes. We would be utilizing the place to store records and peer-to-peer support groups. So it's
Okay, so would the peer-to-peer support groups be a part of the provision of mental health services?
yes.
Okay, so it would be operating mental health services on
Right.
site?
Mhm.
Okay,
And
so,
we have the accreditation from CARF as well to provide those services.
the problem here is where it is, in the zone in which it's situated. So, to the extent you're offering mental health services and operating as a mental health clinic, that's prohibited use in this district, in this zoning district. So that's one reason that you couldn't do what you want to do in that zone. And also because it is zoned, it needs a primary industrial use. That's just the nature of zoning. That's not anything we can control or change. And so, on the record, before us, it doesn't appear that it's a use that we can approve.
Okay.
I would, have you entered into a lease already at this point?
Yes.
Obviously, the landlord understands that you intend to operate a mental health clinic there. Okay. I'm sorry, I don't have better news for you.
Yeah.
But this is, again, it's out of the control of the board. to grant a prohibited use. Thank you.
Thank you.
Thank you.
Can I get a vote on that, please?
Yeah, with regard to case number 2022-404, 719 North Point Road, use the premises as an outpatient mental health clinic for the reasons stated, prohibited use, but no.
No.
I'm a no.
Following case number 2022-414, 3601 Hickory Avenue, Tim Conder, the appellant.
Good afternoon, Mr. Chairman, members of the board. Peter Previs, on behalf of Mr. Condor, the appellant.
Good afternoon,
He is-
Mr. Previs.
he is
This
on
is a
his
request to use a portion of the premises as a restaurant with outdoor seating, is that correct?
Yes, sir.
Do we have anyone else here for 3601 Hickory Avenue? Okay.
They are in favor, I think.
Some in support, some in opposition?
All in support, I believe.
All in support, okay. All right.
Do we have any opposition?
Do we have opposition to this?
There was a
No one
letter
signed
of
it?
opposition.
Letter of opposition, okay. Well, I'll tell you what, because you're all here in support, and we don't know whether we'll hear from you or not, we'll have you all sworn. How about that? Stand up and raise your right hand.
There we go. Do you all solemnly swear or affirm that the testimony you're about to give today will be the truth, the whole truth, and nothing but the truth? So help you? Thank you.
I don't get the paper ones.
Thanks for that, folks. We want to get our, be sure we have our hands on the letter of opposition. Okay, I'll hear from staff and planning.
So, from what we can tell from the application, there are three things being requested here. One being a conditional use for a restaurant with outdoor seating, presumably under the neighborhood commercial establishment section of the code, since this is in a residential district. A minimum interior side yard setback variance, 15 feet required, 0 proposed, so a 15-foot variance. And a minimum rear yard setback variance, 25 feet is required. The site plan is a little unclear, but we're calling it 0 feet proposed, so it's a 25-foot variance requested. There's opposition from an adjoining neighbor, which you have in the file. Just to introduce this case to the board, there's a lot going on here. So the property is split zoned, which is the first thing. The front half of the property is the church. It is zoned C1. The rear half of the property is zoned R6, I believe, and it's where the former parsonage was. There's a dwelling on the site. The appellant seems to be building a beer garden, and I'm sure Mr. Previs will get into this, behind the parsonage building on the R6 portion of the lot. It is partially built. He received a permit, I think, because the permit office thought that the whole property was C1, which is not the case. The permit was, I believe, revoked. There's the only way to get a restaurant use in a residential district is through the neighborhood commercial establishment section of the code. However, I'll just flag that in the definition of neighborhood commercial, it says a non-residential use that is in a structure that is non-residential in its construction or original use or has received prior zoning approval for a non-residential use as evidenced by permits, construction, or historical evidence of lawful non-residential use. We don't have any evidence of the parsonage portion of the lot being used for a non-residential use. And also, this beer garden is not really located within that parsonage structure at all. It's located to the rear of it, and it looks to be all new construction, but again, it's kind of difficult to tell. Okay, that's all I'll say for right now. Thanks.
Planning Department has reviewed this application. It would like to have the board take note of the fact that the property at the corner of Hickory and 36, referred to as the church building, is in fact a designated landmark structure. So it's very important that if any of this proposed use involves that building in any way, there is going to have to be review and approval by the Commission for Historical and Architectural Preservation. Now, the plans provided with the application do not show any such thing. They show a continuing division by a sidewalk that runs behind that church building parallel to 36th Street, which then leads us to the other part of this, and that is that the parsonage building is the R6 zone part of the property. And there is no record available to the planning department of non-residential use of the parsonage building itself that would justify allowing neighborhood commercial establishment use, which is not to say that there isn't a record of some sort that the applicant may be able to provide to the board. But it's very contingent upon the applicant showing that. The final thing is the plan that was provided for review by the planning staff did not appear to show use of the parsonage building as a restaurant. It appeared to show only use of a new structure to be built along the north lot line that would serve possibly food and certainly would serve beer, because this is referred to as a beer garden proposal. And it appears not to involve use of the building itself, which then raises a question, can that qualify as a neighborhood commercial establishment restaurant if there is in fact nothing inside the building that's on the site? So that's another matter for the board to consider. Subject to that, the department has no objection to approval, provided that if there is anything that involves the church property, that it be reviewed and approved by the Commission for Historical and Architectural Preservation. Thank you.
Thank you, Mr.
Do we
Frank.
have a copy of that memo?
No, I'm reading into the record.
Can we get a copy of that memo?
You could, but it, yes.
I mean, it seems like we should, not just could.
I don't know if it's been officially adopted by the planning department.
These are factors. These are factors I'm bringing up. Sorry.
Yeah, but I don't
Yeah,
have
I
that
will
memo.
make you, I will leave this room and make a copy for you, sir, and for the other members of the board.
Thank you, Mr. Frank. Okay. Sir, go ahead.
Thank you.
With top of mind, those issues that have been raised by
Okay.
planning and staff, please.
I think it would be most illuminating if I kind of went through chronologically, and then if required, I have both the owner of the combined property here to testify to backup information, as well as the contractor who pulled the permits and spent over $200,000 on this, only to find out there were two different zoning districts. So the subject property is a consolidated lot now known as 1014 West 36th Street.
Okay.
That consolidation was done when the current owner, Churchworks LLC, and its principal, Josh Mente, M-E-N-T-E, purchased the property. The SDAT real property, for some reason, when you click on it, it has both parcels as separate lots, but both known as 1014 West 36th Street. If you click on one zoning map, I forget which sites between City View and the Department of Planning's websites, sometimes it clicks on and it says 1014 West 36th Street, C1, and other times, and what brought us here today is the zoning map shows 1014 West 36th Street as C1 and 3601 Hickory Avenue as R6. Mr. Condor and his entity Up the Avenue LLC, trading as the parsonage, purchased the BD7 liquor license from directly across the street, which used to be the Redman Hall, and more recently was the Ducline Devel, if I'm saying that right, the Belgian beer establishment. That license is pending, and the use permit was applied for under the only address that they knew to apply for, which was 1014 West 36th Street. The building permits and the use permit were issued, permit section and zoning enforcement believing that it's in a C1. So a restaurant is a permitted use in a C1. If this is R6, it is only allowable as upon a BMZA hearing for the neighborhood commercial. So basically what we're here to ask for, my client was totally confused about what was going on and why, after he had spent all this money, that it stopped. So he applies for the zoning appeal without an attorney, thinking that he needed a meeting. So you see in the appeal letter, it says, "Can we talk?" But he's since retained me. And bottom line, what his request is for approval of a conditional use in an R6 as a neighborhood commercial, along with a conditional use for the exterior of the building, and I'll get into that in a bit.
Okay, and hold on. Ms. Witt, is that consistent with what you understand to be the request before the board?
Yes, that's consistent with the conditional use portion of the request. He also needs variances for interior side yard and rear yard. But yes, that would be the only way that restaurant is available, is approvable in an R6, is through the neighborhood commercial establishment section.
Okay.
Now, the contractor and the landlord were always under the impression that when the lot was consolidated, that the higher use applied to both sides. It's not in Ms. Witt's notes, but I will point the board out to and concede that the current zoning code under section 6-304, property divided by zoning district line, indicates where a lot is divided into two or more parts by a zoning district line. One, for all purposes except density, each part must comply with all of the regulations applicable to its zoning classification. And two, for density purposes, the lot area computation of each part may be totaled and then distributed throughout the lot without regard to zoning lines. I hadn't had occasion to look to see if in the 1971 zoning code there was a comparable section. I would assume that there was, but I honestly don't know. But the property was purchased in 2019 after enactment of Transform Baltimore. But it appears that that's where the confusion has abounded.
Okay.
Mr. Menti, Churchworks LLC, the landlord, when he purchased the property and consolidated the lots, obtained a use and occupancy permit for offices, and all involved, including him and zoning, believed that comprised the 3602 Hickory, in which there are offices. So when you get into the issues with regard to the neighborhood commercial, which is defined at 1310J, it indicates neighborhood commercial establishment, quote unquote, means a non-residential use that is within a residential or office residential zoning district, but in a structure that, one, is non-residential in its construction and original use. Here we have a parsonage, which in general parlance would be the preacher's living quarters next to the church, although we have no idea whether there were offices or anything else in there. Or, not and, but or, two, has received prior zoning approval for a non-residential use as evidenced by permits, construction, or historical evidence of lawful non-residential use. So we have Mr. Menti here to indicate that the make of the property went back to 2000. There was a residence in the parsonage, but everything else was offices, and then he obtained a zoning use permit for all offices in 2019 or so. So I'm not sure, he'll clarify whether there was offices on the first floor of the parsonage building or it remained either vacant or residential. But he clearly, in his mind, he obtained a use and occupancy permit for the consolidated building of 1014 West 36 for offices. To alleviate Mr. French's concerns, the church, the old Grace Methodist Episcopal Church, is on the front lot, which is 1014 West 36th Street. And this is the parsonage property, which is 3601 Hickory. The proposed area does not encroach upon, in any way, shape, or form, the church building or lot. It's all behind the parsonage building.
Okay. So you've indicated that there is a residence, there is or was a residence within
Was. The parsonage being the preacher's quarters, directly next to the church.
Okay.
Okay. So with that said, I would like to briefly call Mr. Condor, Mr. Mente, and Mr. Van, the contractor, to explain, to put on some facts so that I can close with why I think this is an appropriate request.
Okay.
Thank you. I call Mr. Condor. State your name.
Tim Condor,
Spell your last name.
Conder.
Okay, and you applied for this, what I described?
Yes.
You were sworn, right?
Yeah, yeah, it's all good. Really, to keep it short, I've spent close to at least closer to $300,000, because when we were given permission by the city, we were moving forward, and we actually got all of our forms paid down, all of our development stickers signed by the city until a couple months ago, before it came up, and 2 were pulled by the business downstairs.
Okay, so let me just, I'm going to ask you a couple of questions with regard, so the board can understand what your proposal or your plan is, okay? All right, so you had pulled a building permit and use and occupancy permit proposing a restaurant use
Yep.
behind the parsonage building, is that right?
Yes.
Okay, now, in the back of that property, there is a garage that would fit 3 vehicles?
There's 3 buildings that they turned into garages that holds 6 or 7. And in the first conversation, because the road is a ramp and it goes up like that, so we had been given permission to make those roofs all the same size, and that's where we built the bar.
Okay, so let me go back. So you hired an architect for this project?
We hired a contractor.
Okay, and you had plans that were approved?
Yes.
And your contractor pulled building permits?
Yes.
And you began construction?
Yep.
You did more than begin construction. You spent close to $300,000 already.
Exactly.
Okay.
Well,
Now,
because everything that we talked to with the city was approved. And more recently, and we even tried to talk to the neighbor, or the guy that owns the building next to us, that I think he's probably the reason that we're here, because he has an issue with what we're doing. And I tried to contact him several times, and I spoke to the city.
okay, let me, all right, so now there's 3 prior garages that are all next to each other, attached, right? 4, okay. And your proposal and what you already constructed is you flattened the roof of the
So instead of going up
garages?
a hill and each one being a little higher, we leveled them all to the same height.
Okay, and then you constructed a structure on top of the garage,
We did,
and that is all done?
yes,
Okay. And in that structure, you would have your kitchen facilities
yes,
as well as your bar facilities?
exactly.
All right, 3-compartment sink, hand sink, everything else that's needed, kitchen equipment?
Everything that's needed.
Okay. And your proposal was in the yard area, now from the garage, there's steps down to the
There is
yard?
steps down
To
or
the ground
up.
level? All right, and you've proposed tables on both
Yes.
the level above the garage where the The building is as well
There
as
can be
in the yard?
tables up or down.
Okay, and you've proposed about 12 to 15 tables, is that right?
Yep.
Approximately 50 seats.
Exactly.
All right, and you understand you cannot act, your plan said beer garden, but you understand that this is a proposal for a restaurant?
We changed, that was the original name. We changed that because we saw that it was being upsetting.
Okay.
Sure. I have a question.
Yes,
In
sir.
the larger context, what's the church being used for?
Offices.
And that's your project?
That's the landlord.
It's the landlord.
And it's
And then
been,
there's the parsonage.
yeah,
What's the parsonage being used for?
offices.
Offices.
Yes, sir.
And then this restaurant proposal that he's trying to describe is separate and distinct?
Yes,
in
so
the
there,
rear
so
of the
there's
parsonage?
It's the yard and over the buildings
Right.
in the back.
So fronting on Hickory is the house, house, parsonage building, whatever. And then there's a yard. And then there's the old garages. And then built upon having obtained proper permits at that time that were subsequently revoked, a structure on top of the garage and a base floor on top of the garage.
So the garages still exist?
Yes.
What's going to happen with the garages?
There's still the gentleman that owns and operates the business that we're gonna rent this area from has some of his clients park in there.
His tenants,
So this restaurant is a totally outdoor operation?
yes.
No indoor seating, no indoor,
It's outdoors,
There-
basically gonna be a summer project.
There's I'm sorry,
you offer food,
yes.
and where's the kitchen?
In the structure that was built on top of the garage.
Okay. Thank you.
Do you want me to take judicial notice of this?
Okay. So, since Mr. Cunningham asked, what would be your proposed times of use for this?
I think when we first opened, we would do a Monday through Sunday to see if that works. and
Okay,
if
but what
not,
time of the year?
Spring to fall.
Okay. Not when it's,
Since it's outside, we would, just like our mini golf course, we would shut it down at the end of when it gets too cold. In April, we'd warm it back up.
currently no proposal for tents with heaters or anything like that? Okay. All right, now,
How about entertainment?
not allowed and not contemplated.
Not live, but there might be music played on either from the radio or played at a low level.
But not anything that would come within the definition of live entertainment.
No.
It's totally not allowed. Okay, and you've discussed this issue with the neighbors?
We have.
And have you received opposition or support?
We've received all support except for the gentleman that owns the building one north of the backyard.
Okay. And the folks that are here today are all in support of
Yes.
your proposal? Okay, and you would you be the full-time operator?
No.
And who's gonna make sure that there's no noise complaints or?
Well, they can all have my number, but I'll be there sometime, but probably we'll have somebody engaged to basically be our full-time employee.
Okay, but you'll be hands-on? Is
Yeah,
that- Okay.
100%.
Okay,
So the neighbor that you're referring to your knowledge, is that Wayne Gioso?
yes.
Okay.
Is he here?
His letter in the file indicates that he would be present today, but it doesn't appear to be here today. Is it accurate that the stop work orders associated with the project were all related to the advice that it's a split zone
Yes.
and that you were not permitted to
The only name by which anyone knew to call this property was 1014 West 36th Street. When permits reviewed the application, they looked up 1014 West 36th Street and it said C1. It was only after the expenditure of the monies, and I don't know if it was a result of Mr. Gioso or not a result of Mr. Gioso. Apparently, he had a complaint with one of the upstairs windows the sunlight being blocked. was his issue, at least according to his testimony at a prior liquor board hearing. But that's what happened. This gentleman did what he was supposed to do, obtained the proper permits, did the work, spent the money, and then only found out that there was a mistake because there was a split zoning in this lot.
Do you know if Mr. Giosa resides in the?
He does not. He lives in Baltimore County. I know Mr. Gioso. The building that is there now, there's an individual that uses it to store items that he sells, and I believe Mr. Gioso stores other items there. There's no residents in there, although it's zoned R7. The rest of the area is R6. That particular building is zoned R7. Okay, if I can briefly call the landlord, Mr. Menti from Churchworks, to confirm what his prior knowledge of the.
Good afternoon.
Mr. Menti, can you state and spell your name?
Josh Mente, last name is spelled M-E-N-T-E.
And you were previously sworn?
Yes, earlier.
Thank you. Now, and is it, you are the owner through your entity, Churchworks LLC, of both
Yes,
properties?
I'm the operating principal partner.
And when did the entity purchase these lots?
1014 West 36 was purchased in January of 2019, and the house subsequent after that in February of 2019.
Okay, and then you filed to consolidate the lots?
Yes, somewhere, I don't remember the exact date, but it started in 2019 and may have been approved. You guys would probably know better at the latest early, what's the date on it? Yes, it was approved summer of 2019.
July 23rd, 19?
July 23rd.
Okay. Now, were you familiar with the property prior to its purchase?
Just from being in the area in
Yes.
Hamden as a.
Okay, and when you purchased a property, what was the use of the church building first?
So the church building was reconfigured as office space and occupied in 2001 by an advertising agency. The intended use for me was to continue as office, but reimagined as 21st century, basically co-working space. We micro-rent the offices and have other events and things like that there.
Was that throughout the entirety of the building? Offices throughout the entirety of
Correct,
the building?
yes. We just continued on the same purpose of the building.
So staying with the church space, the prior user back to 2001, it was a traditional office?
Yes.
And currently you have certain tenants that rent offices and others that operate flex space?
Yeah, so the easiest way to describe it, you would normally have a building like this that one tenant rents. We actually basically own the building, are the master landlord, basically. And we rent each individual office out separately. We rent desk areas. We have common areas where they can take a membership and come in and use the amenities, conference rooms, things like that. It's co-working space like we work, basically.
And to your knowledge, did you obtain a use and occupancy permit for that office use?
In 2001 was the original use and occupancy permit, and then through the transition of ownership, we went through all the different parts.
What was the zoning designation when you got your use and occupancy permit?
C1.
C1.
Yeah, it's been C1 all along. And I think that's kind of some of the confusion how we end up.
Yeah, yes, I'm confused because I'm looking at this document, which says R7. How does that happen?
Which building are you referring to?
So 7 is Mr. Gioso's property, Mr. Cunningham? So in front of that, if you have Hickory and then you have 36th Street. So the church is on the corner of Hickory and 36th. The Parsonage building is one up from there, and then Mr. Gioso is 2 up from there.
I see, I had it reversed.
Mr. Gioso is the one that says R7?
Yes.
Okay.
Not sure why he's different than everything else up Hickory, but everything else is R6 as far as the eye can see.
I could probably lend a little bit to this if you don't mind. So if you're on the street, and I'm there every day, so it's very familiar to me. You got Redmond's Hall across the street, you got the VFW Hall. Basically, it's all commercial running down the west side of Hickory. Everybody knows the Avenue, 36th Street, everything is C1 commercial there. As you come back Hickory, the other side, you have the church, a parsonage house, and then you have a 15,000 square foot warehouse. It used to be everything from a belt factory to, I think, dog leashes, underwear, a bunch of stuff like that. And it's not vacant since Mr. Gioso bought it, and recently he put in, I want to say they sell like vintage furniture or whatever it might be, and then he stores a lot of things that he's acquired over the years. So it's basically a warehouse storage facility. Technically, it is R7 zone, but it's more commercial than it is anything else, or at least one of the other designations I think would be better suited for, an old warehouse. So the house itself, the parsonage house, sits in between sandwiched, all commercially either visible or actively used properties. So in and of itself, it's kind of an anomaly that's sandwiched in as a donut. The property itself, the history of it, as I know and understand it, was all one parcel. Now, there was a pastor that bought the building in the 80s, somewhere in the 80s, and he, for extra money, had subdivided the parsonage off and sold it to someone else. So he, when he did that, had retained the church, and then in 1999, the church caught on fire, at which point he couldn't afford to rebuild it, then sold it to Jack Gilden. Jack Gilden Advertising, then turned it into basically an ad agency office, and then it kind of moved on. That house sat in between this warehouse and was connected at one point, and I don't know the exact, but if this has been C1 all along, when it was all on one parcel, it would have been C1 at that point as well. So when it got subdivided off, wherever it goes through zoning, the remapping, like all the stuff that's happened, I don't know the whole history of it, but at one point it was part of it and then subdivided off, and now it was just including it back into.
Tom, I know you all said this before, but when were the church and the house consolidated, the two lots consolidated again?
July 23rd,
23rd,
2019.
I have a copy of the
2019?
approval, if it would help the record, or,
I mean, it's your choice, it's your case.
sure.
Yeah, so I consolidated in purchasing both. It
Okay.
was like with the intent, when bought both, it makes better sense as one, because the original concept was to build a parking lot in the excess acreage that abuts basic on the east side, there's an alley, and then Hickory on the other side, retain the house and build a parking lot to service the buildings. That was the original idea of like why I assembled the properties.
Gotcha.
I did get that parking lot actually approved, then COVID hit, and it was like, I don't know if we need a parking lot, because I don't know if anybody's coming into offices anymore. So I'm just kind of filling in the whole back history of the building since I've had it.
I have another question, a logistical question.
Yep.
How are people going to get to this? Through the alley or like down that little path between? How are people going to get to the bar?
Yeah, so on 36, there's actually a natural sidewalk that bisects what is each property. So that would be the way that people would be able to come in. There
Is
is,
it on 36 or on Hickory?
oh, I'm sorry, on Hickory, I apologize, yes. There's no access directly from 36th Street.
So it's just that sidewalk that goes between the church and the house?
That's correct.
That's the,
That sidewalk does go all the way out to the alley as well, so there's 2 points that
Oh,
could
okay.
technically be
And
used.
there's currently a gate on the alley where people can access the rear from the
The
alley.
sidewalk is open. It's basically, it's
Okay.
used as like public
I'm
right of
sorry,
ways. how
there's
people are
there's
using
a gate for the yard.
The yard itself would be sectioned off completely from this, so it can be closed at night. It's the idea of what it should be, is that it's its own little thing, can't spill off on the sidewalk and things like that.
when you say the yard, do you mean this bar or do you mean the yard to the house?
So it's kind of one and the same, basically,
I
right?
gotcha.
So, some things to also clear up, if I may. So the garages are actually, there's 5 parking spots. Those were kept to use and for the office space. Basically, we rent them out specifically. On top of that, the general assumption of all of this has been, and I think my hope would have been, it would have been flagged somewhere along the way. The person that helped me do it, yes, it all converts one deed, it's C1. It goes downstairs. When we fast forward, basically at some point it would have been flagged there. Even how it was approved under C1, the reason that he's talking about the variance is because there are no side setbacks or rear setbacks in C1. That's why that building was approved to actually put there. It's like 15 feet wide by 20 feet. It's just a smaller structure. Somewhere along the way, it should have been flagged that even that in of itself would go against what the zoning code is for the actual R6. So Mr. Conder has gone through, kind of done all that stuff, and we were all operating under the same premise that this was C1 zoning. And permits got approved, construction started. all based on C1 parameters, basically, because otherwise it would have been a variance to get the building constructed where it is. Unfortunately, now towards the tail end is when, the issue comes up and we're coming back to try and figure it out.
The final piece to this is the use of the parsonage building currently and historically.
Historically, I only know like what I know, right? So I filled you in on that it was used historically, was part of the property itself. I don't know if I've heard that it could have been used as like Sunday school, right? Where they come in and do those kind of things. I do know that the former pastor at one point had lived in that house, and then the use in between was actually as a residence. Since then, and again, goes along the same lines of it's all C1, we actually keep the house and rent the bedrooms and everything else as continued co-working space, basically. So it's being run as an office.
And how long, since you've had it, it's been used as an office?
For me, yes.
For 2019? 19, okay.
Well, basically, once it got consolidated, we were able to then go in and use it that way because we were under the assumption it was C1. I shouldn't say assumption. That was what was, I think, conveyed to me and what was understood. Even like with our tax bill, I only have one tax bill now, is 1014. It still shows up as C1. There really wasn't anything along the way that I could have picked up on that would have told me anything other than what we're working on the assumption of.
Okay. With regard to the configuration of the church, were there areas for Sunday school or meeting hall, or was it just a church building?
You're talking about historically before?
Historically.
Yes, there was absolutely Sunday school. They used to have it. In fact, the former pastor, once he opened up his co-working space, came back and started having his Sunday services there in the former Sunday school space, which is the lower level where we have a big open area. So it's actually kind of
in the church?
In the church, yeah.
Okay.
Yeah.
What the board may be interested in is any non-residential uses that you are aware of historically for the parsonage building.
Non-residential, I cannot confirm specifically other than what I had said to you that I had heard.
But from the layout of the building.
You're asking what is the layout of
The parsonage building.
Have you been inside the parsonage anytime within the last couple of years?
Me? I've
Yes.
been there almost every day. So
Okay.
I'm an active owner on site, so.
All right,
Yes.
so what's it look like?
It looks like a house, right? But in just like you would see a house that's an office, right? So the way that it's set up, it would
I
be like.
have a house that's an office, and I sleep there. It's or my residence.
Nobody sleeps there, so
Okay,
it's
that's
not
important.
active. Yes, nobody sleeps there. Nobody has slept there since I've had it. So it's not set up that way.
For 3 years, it's been all offices and some
100%.
Sunday school.
100%.
Okay.
Well, no.
The church in the Sunday school.
Well, they're no longer a tenant anymore.
Okay.
So they had rented it and done their thing, but then
Gotcha.
kind of just didn't work out. They grew, or I don't know.
You have rooms that used to be bedrooms but are now
Yes,
offices.
if you walked in there today, it's all set up as desks. Yes, there's 3 or 4 desks in one of them. 3, 2, 1.
No
and then-
dressers, no closets, no makeup
nothing.
tables.
Yeah, you can walk in there today and there's nothing. Even in the basement, there's a nonprofit that rents it that basically rents out the whole basement as their office.
Okay.
Thank you. I have no further questions unless.
Let me see if I may, let me see if I got this right. So you're proposing a one-story addition at the first floor rear. That would be in what looks like a yard?
Yeah.
And then the deck would be on top of the garages.
Yeah, so the actual.
I'm sorry, go ahead.
Do you want me to finish? All
You're
right,
the witness.
So yes, if we visualize it like this, the garages were here and there was no roof on
I'm
it.
looking at this.
Okay, would you like, can I approach?
Okay.
You can hold it, Tim. You can use it as a
take
display
it.
and point it out.
Yeah.
Oh, okay.
And still speak to the mic.
Yes, stand, I'll give you my mic and you can stand right here so we can see you.
Oh, okay. All right, can you hear me?
Yes.
All right, so you can see back here, these are the garages. So this is the warehouse that I was referring to. So these garages don't have a roof on them, right? So what happened is basically, they were at varying levels as you step down. They were brought down to the same height and a concrete decking system was put on top of it. Now, with the approval and the permit, there is an actual structure that was built based on the permit, which is basically here in this corner. So this is all basically like open decking area. And then the backyard back here is basically Right now, it's gravel waiting to be finished and would have like picnic tables and things like that. So the idea being that it's kind of, when it got approved under the C1 understanding, that's where the building was approved to be placed, and it's actually already been constructed.
So it's a 2-level beer garden.
Yeah, so if you think of it like this would be like the main level, and then there's a set of stairs that go up on top of the concrete above the garage, so then there's like open space.
Question.
All right.
One more question for clarification of Mr. Cunningham's question. So there is one structure that's clearly built above the garage, correct?
Yes,
Okay, and is there any structure in the yard?
there are bathrooms that were
Bathrooms.
placed up next to the house, separate from, and again, it was all part of the permit that was filed, that was approved. And those 2 bathrooms have been, I think there's actually 4 bathrooms, but his and hers, or I don't know the proper term, I apologize if I didn't use it.
Bathrooms is cool.
Bathrooms is fine.
Yeah.
So there's 2 separate bathrooms, each have 2 ports in them. But those are the only structures that were, again, filed for with the permit and approved to be constructed.
Thank you. I have no further questions.
And there's no opposition, right?
There is a letter of opposition.
Oh, which,
I don't believe that that person is here. I have a question, though. Do you have a use and occupancy permit that reflects any non-commercial use of the parsonage building?
Again, it was all as one deed, and so my assumption was, so anything for 3601 Hickory specifically, I can't specifically sit here and say that I have something for that address specifically, because everything's been under 1014 once consolidated.
So the UNO for,
If I, board's indulgence, I'm just going to look at the, what I can tell from the property. Okay. I can't tell from this property, but is your understanding that you pulled a use permit, or that you were under the assumption that since the prior owner had obtained offices, that
So
was included?
I have administrative staff that's tasked with doing certain things. So for myself specifically, I did not go pull a use and occupancy permit. You had said that it noted on here that it was. What I do know is that the use of the building had been approved. Again, under the same assumption, it's all C1, so it all kind of like falls within like where it should be.
Okay. Thank you. I have no further questions. If the board would like to hear just very briefly from Mr. Jesse Van, the contractor, to confirm that he got drawings, he got permits, he did everything he was supposed to do, other than he found out later that the zoning was not.
I'll just keep it real brief.
Okay. State your name.
Jesse Van, V-A-N-N.
Okay. And Mr. Van, are you the contractor on this
Yes.
project? Okay. And explain to the board what you did and the
So
reasons that
there
you
was
got.
a permit that was approved in 2020 for a parking lot that went through zoning, was passed by the city. Then I tried to actually apply originally on 3601, and I had the message board. I was unable to apply under that address. They made me apply under 1014 West 36th Street. They communicated to me that this was a C1 zoning. So I had to change everything I did, put it on 1014 West 36th Street. I got all my final building permits. I had the fire marshal sign off on the use, the plumbing and electrical signed off on everything, and we're done work at this point. And then I go to get the health inspector and the final building inspector who's ready to sign off on everything, but there's a flag in the system and there's a hold on it that I have no idea where it came from. I looked into it, it came from zoning. I spent so much money sending people into zoning to try to get answers on this. Half the people in zoning agree that it was C1, half didn't. No one could give me any direction on anything, but the reason we're here, to keep it short and sweet, is they made me apply for 1014 West 36th Street. They confirmed that it was a C1 zoning. So we did everything, we spent all the money, and we were literally at the final step just trying to get the paperwork after the file marshal had just walked and passed us for the use. And then that's why we're here. So I really don't have any other information other than that. Also, the garages, we didn't go outside the footprint. That's been there forever. So you can look on historical images. We didn't go outside of the footprint that was already there. We went on top of that footprint. And we did everything that the city basically made us do. And now we're here, spent 300 grand, try to get 2 more sign-offs on everything. And, you know, this has taken 3 months and cost a lot of money.
Okay, one final question with regard to, if anyone looks in the city's computer and sees a stop work order.
Yeah.
That wasn't as a result of you not pulling a permit, that was a result of you pulling a permit for the
Exactly.
other address?
And they made me move it from 3601 over to 1014. They issued simultaneously stop work orders on both those properties. I cleared up the one on 1014. That's why I've been able to get all my sign-offs, because we're in good standing. Yet there's still this address in their system, 36001, that doesn't technically register on the building permit side. So it's really confusing. So
Can I ask staff a question?
Sure.
It's a question for staff. Based on what he just said, and I've heard the same thing at other times, is this a problem that's typical of the zoning office downstairs?
I hear a lot of things about the zoning office downstairs. They probably hear a lot of things about us upstairs. I do think that it's unusual and difficult that it is a split zone property, and that is definitely confusing.
I guess I'm just sorry to say one more thing.
I often ask questions I know the answer to.
I know, and I avoid answering questions sometimes.
I guess our biggest concern is that there was 2 permits that went through zoning's office, were stamped and approved. 2 permits, not just this one. They were stamped, approved, paid for. In addition to that, we paid and were approved from a use permit. It went through zoning office. This all went through zoning office 3 times as a C1 property, and they passed it. So that is kind of ludicrous that we have to come in here, spend 300 grand, and then, you know, that should have been, that's the whole idea of going through zoning to get passed, is to get it done there.
Thank you, sir. I have no further witnesses, and that's most respectfully request that the board approve this request for the neighborhood commercial, as well as the conditional use for the outdoor use of the property for where the tables would be. I believe there's sufficient evidence of the prior use as offices. There's ample evidence of confusion with zoning in and of itself by reason of the consolidation and the unconsolidation and then the consolidation again. And these folks were totally well-intentioned and did things by the book and are now close to $300,000 into this project, and most respectfully request that the board approve it with the appropriate variances.
Thank you.
Thank you.
Thank you.
Thank you.
All right, if we start at the bottom and work our way up. No, that's it.
So I just want to make sure that you all are to draw your attention to the definition of neighborhood commercial
Yeah.
establishment.
You mean the
The
neighborhood
part that I
commercial-
highlighted specifically.
Neighborhood commercial establishment means a non-residential use that is within a residential or office residential zoning district, but in a structure that is non-residential in its construction, original use, or has received prior zoning approval for a non-residential use, as evidenced by permits, construction, or historical evidence of lawful non-residential use. I think we have plenty of historical evidence of lawful non-residential use.
Through the testimony.
Yeah, that was given today. That was,
Is it in the structure is what you have to decide. Is the use in the structure that is being requested here?
if it's on top of the garage, I think it is. Because the garage is part of the structure. Because technically the property has 3 separate structures. And this would be located within one of them.
Parsonage, garage.
It's definitely a structure.
Yeah. They had to do construction on it to level it off as part of the process of making this. think it is in a structure that has historical evidence of lawful non-residential use, based on the testimony that we heard today.
Well, the use
I
of
have-
the,
So if you're saying that, then it opens up anybody with a garage to use it for neighborhood commercial going forward.
so
Is
that's the
is
portion
a
that's being used, there's a garage,
I mean, I think we see a lot of garages that have been converted into restaurants. I don't think this is the first one. It's just unique because it's not the front of it, it's not the inside of it, it's the top of it.
Have we done a garage in like a residential, behind a residential property? That's been converted to like a neighborhood commercial? I haven't seen that yet.
I believe you're onto something, and what I was gonna say prior to your comment is that we're not dealing with just a single-family row home, we're dealing with a church that had buildings that are a combined garage that fit more than one car for each thing. So you don't have a traditional garage in the sense of a one-car garage attached to a single-family dwelling. You have a garages that are attached to a commercial church use.
Like a line of them, which suggests commercial
Right.
use. If you have
Yeah.
4 open spaces together, however many there are, that suggests lawful non-residential use, unless you have a really big house out in Howard County somewhere.
so this issue of the definition and the structure, because obviously the parsonage, church, all that is not where this is being built. So it's only the garage, which is a portion of the,
It's a portion of the general church structure. We call it a church house, not a parsonage where I come from. So it's a portion of the church house, essentially. But it's been used commercially up to this point. I mean, I'm just saying what I think. I don't know.
okay? Structures not has received prior zoning approval, non-residential use as evidenced by delivery on.
I think I'm open to the idea that these garages have been used in a non-residential manner.
I believe that one of the gentlemen that testified said that they park there when they go to work. That feels like, or like some of the office space that they rent uses those spaces as parking spaces, which would generally then make it, just because the garage doesn't have like a breezeway attached to a building doesn't mean it's not a part of that building.
Right, exactly. It seems like it's secondary to the use,
Yeah.
which has been used as the office for the parsonage has been currently used as office space. So these garages have been attached to a use of an office space.
They're attached by like heart and soul and not by brick and mortar.
Exactly.
Mr. French, for purposes of determining the structure, given the layout of these several structures, would planning conclude, is it planning's position that the garages are part of the structure?
I doubt we would conclude that, but I believe we heard testimony that there is a structure built atop the garages.
Right.
That the concrete deck was poured as a roof for the garages and also serves as a foundation for part of the proposed use.
Also not
that's
the
being
garages
approved.
themselves, but the structure that is on the garages.
And that apparently received a permit, according to what
So
I believe I heard.
that of itself is a structure, separate from the garages, although it's attached.
I think they mentioned 15 by 20 feet as its dimensions.
And that's for non-commercial use.
Yeah.
So lawful non-commercial use is the thing that leveled out the tops of the garages.
Okay, thank you.
For me, he just hit on something, the fact that it was granted a permit.
Yeah, there's a lot.
On the other hand, it does clearly say in a structure.
Yeah.
Not on top of a structure.
I mean, from a legal perspective, the fact that permits were granted and
how I
then
really feel.
withdrawn is kind of
That's
not the
their
point.
What was that again?
From a legal perspective, you actually can't rely on what the city tells you is true.
What?
It's true.
What?
You can't, so if the city tells you something wrong and they give you a permit, that doesn't mean you're entitled to the permit. I think that we all know that, right? That's why it was revoked and they're not able to move forward. So the fact that they were issued a permit and then it was revoked doesn't mean anything to your discussion right now from a zoning perspective. I know it doesn't seem like that should be right, but it is. You can't rely on city agencies to tell you the truth.
That's news to me.
That's on the record, Becky.
I know. I'm protecting myself here.
Okay, that's fair.
Garage is the structure that we're talking about, that it meets the definition.
Yeah.
But if the garage, we conclude that the garage is a structure,
Yes,
non-residential in its construction, original use.
yes.
um,
The next
think
step
there's-
up is then we can consider the neighborhood and commercial use, right?
Right.
I think that's the easy part, right? There's 50 people who are here and very little opposition. It's the getting to that part.
Yeah, and I think that sort of the base thing is established through the garage portion, the structure that, how it's been modified is non-residential in its construction and use. Putting aside whether or not there's prior zoning approval, put aside zoning approval, just that is non-residential in its construction and original use. I think that satisfies the requirement under neighborhood commercial.
I agree.
So what's the rest of neighborhood commercial?
The rest of it's a conditional use standard, right? And conditional use and variance standard. I think that for the variance standard, it'll be very easy for uniqueness. This is definitely a unique property.
Okay.
Do you want to go through those? You want me to go through those? All right, so for the three things that are being requested are, and Bill, I'm cheating off of your, for conditional use, in order to deny conditional use, we'd have to find facts and circumstances that show that the particular use as a restaurant proposed at this location would have adverse effects above and beyond those inherently associated with such a use, or irrespective of its location within the zone. Given that C1, that this whole property is C1 and that's it's next to the avenue, I don't believe we can deny this conditional use. But to go through the questions anyway, the establishment, location, construction, maintenance, or operation of the use is not detrimental to or endangering of the public health, safety, and welfare. We've had no evidence, to pull out some facts, we have no evidence that it would be detrimental to that. It's not precluded by any other law or urban renewal plan. There's been no testimony that it's contrary to the public interest. The sheer number of people that are here to testify to make it get there is actually answers that question. And it is in harmony with the purpose and intent of the code, given that this is a C1 property. So I think for the conditional use as a restaurant with outdoor seating, I think it meets all of the standards.
Sabrina, it's an R6.
It's an R6? I thought my bad. I thought that was combined and it was C1.
No, it was combined, but the parcels keep their zoning. So the part in the back is R6 and the
Gotcha.
part in the front, which is the church building, which we're not talking about, is
Gotcha.
C1.
So erase all the parts that I said just now that included the word C1, but keep all the rest of the content. even though that can't happen in the record, but that's what I meant.
And let me just add that with regard to the opposition that was presented by virtue of a letter, not in person, I don't think that stated opposition in that letter dated November 5th, 2022, Wayne Gioso rises to the level of meeting the test for denying a conditional use. Specifically, the opposition raised issues regarding prior stop work orders. I think that's been thoroughly explained and why that occurred. And there was some concern about the integrity of the outdoor project. I'm not exactly sure what that means, but I don't think any of that rises to the level to result in a denial of the conditional use.
I agree. And as for the variances, there's a minimum interior side yard variance requested and a minimum rear yard variance requested. So question one, are the conditions on which the application is based unique to the property for which the variance is sought and not generally applicable to other property within the same zoning classification? I would say it is because of a number of factors, one of which is that it is part of a consolidated parcel, but where, no worries, it's happened to me 1,000 times, where it's part of a parcel that was two different. It was,
I think you're gonna have to throw it against the wall and make it stop. That's all it's
no
left.
worries. It was part of a parcel that was consolidated from two different zones, but it's still one property, but each retains their own. So that's unique. The fact that it is that kind of all the properties surrounding it are all kind of different. I think that makes it unique. Does anyone else have any facts to put on the record for what makes this property unique?
Yeah, I think that's sufficient.
Okay. It would, so it would be an unnecessary hardship or practical difficulty to apply the strict letter of the law because the structure on which this is being built is already there. So you'd have to like push the garage back, and that doesn't feel, it's difficult. It would render conformity with such a restriction unnecessarily burdensome, given that you already have the foundation for this restaurant in these garages that already exist. And that unnecessary hardship or practical difficulty is caused by the code. It's not caused by any intentional action or inaction of any person. None of the people who testify said that they were the ones that put the garages right there, so it's not based exclusively on a desire to increase the value on it or income. In fact, if you leveled the garages and like made the whole thing a beer garden, that might actually increase the value, but I don't think that, no one's mentioned money at all, and that's just my speculation, obviously. But no one's mentioned money at all. It has nothing to do with the desire to get more chairs in this bar or whatever. It will not be injurious to the use and enjoyment of other property in the immediate vicinity. The only letter that we have in opposition doesn't even mention that, right? It just mentions things about construction and permits. The variance is in harmony with the purpose intent of the code. There's not an urban renewal plan for this area. I don't know of one that would apply to this. The city's comprehensive master plan, and then since it's not touching the actual church building, which would need the historical and architectural preservation district protection, that doesn't apply. And then just as with the conditional use, the variance is not otherwise detrimental to or endangering of public health, safety, or welfare. It's a pretty well planned and thought out restaurant in an area that's next to a bunch of other restaurants. So I don't believe it to be contrary to the public interest. So for those reasons, I am in support of approving the conditional use and the two variances.
I can agree with the conditional use and the variances.
I agree.
I think the,
I'm sorry.
When you look at the conditional use neighborhood commercial, I think it's like, the rationale is a bit of a stretch, but I also think I could go with that stretch.
I agree for the reasons stated.
I also agree. I think this passes the Schultz test.
All right, great, thanks.
Okay. Yeah. We need to go off the record for about 5 minutes.
All right, we're off the record for a quick break. Thank you. Okay, are we ready to go back on the record?
Yes. So let's call case number 2022-429, 3405 7 Mile Lane. Is that the right one?
I think we, yeah,
That was approved on consent.
I am giving a consent case. Nope.
we skipped 406.
801 South Haven. One that has Massachusetts name attached to it.
Yes. Good afternoon. Caroline Hecker, Rosenberg, Martin Greenberg, on behalf of the applicant. I'm joined by my colleague Drew Tilden, Jamie Frazier on behalf of the developer, and John Kraft of Kimley Horm, our civil engineer. With your permission, I'm going to blow through this pretty quickly because there's no opposition and I have a 4:30 meeting, and so I am trying to get there. Ms. Tilden is handing out a file full of exhibits, and I'll walk through this. I know I talk too fast to begin with, so feel free to interrupt me. This is an application. Actually, should I let I see you like ready to like jump in on me. Should I let that?
Typically, we get the reports if we have them. I think they can be succinct and we can get them stamped.
2 variances, minimum interior side yard setback, 10 feet required, 5 feet proposed, 5-foot variance, and minimum rear yard setback, 25 feet required, 5 feet proposed, 20-foot variance requested. And I flagged something in the memo for you that we can discuss. I'm sure Ms. Hecker will address it. Thanks.
Planning Department reviewed this application. This particular property's development is pending some approvals by the Planning Department, and specifically because there's a subdivision involved with part of this property, there's a requirement for Planning Commission approval of the subdivision and development plans for this property. The Planning Department is also concerned about the fact that the land use being applied for is something that's not allowed under the current zoning of the property. There is a bill in to rezone the property, but we would just like the board to be aware of the fact that until the rezoning is complete, the application may not be finally approvable. The department was recommending deferral of a complete hearing and deliberation for that reason, as the current zoning of the site prohibits multifamily dwellings, which is the proposed use. When the board determines that the new zoning would allow approval, the department recommends approval be conditioned on construction or installation of all aspects of the proposed multifamily dwellings and related off-street parking and landscaping in accordance with plans approved by the Planning Commission and the Department of Planning. Thank you.
As I can say right now, as a former city council person, I don't feel comfortable moving forward with a pending zoning bill.
Oh, make sure to turn your microphone on. Sorry. Me too. I will also make sure to
Which
turn.
is the outcome, no vote.
Yeah. So.
May I address that?
Yeah, you may.
This is not the first time the board would have heard and approved, hopefully, an application pending a rezoning bill in the city council. This rezoning bill has already had its planning commission hearing. It has already been heard by the Economic and Community Development Committee in the city council. It went to second reader last week on the 15th. It'll go to third reader for final passage at the first meeting in January, on January 9th, and it should be signed by the mayor shortly thereafter. We have no reason to believe that the bill won't be passed. And what I would suggest is that if the board is inclined to approve the application, that it be approved subject to the condition that the property be rezoned in accordance with City Council Bill 22-261. Okay. So this is an application, as Ms. Wood indicated, for certain setback variances related to the construction of a multifamily townhouse, rental townhouse project on Haven Street. It's listed on the docket as 801 South Haven, but it actually consists of 4 lots. It's 715 South Haven, 801 South Haven, and then 2 block and lot numbers that don't have street addresses that are former railroad rights-of-way. Those 4 lots or portions thereof are being rezoned in connection with this City Council Bill 22-261 that, as I mentioned, is pending in the City Council. And the purpose of the rezoning is to rezone them from the I2 and the IMU2 zoning districts, which are industrial districts, to the R8 zoning district. These properties are former railroad rights-of-way and former industrial properties. And they are being rezoned to be consistent with the adjacent property, which is zoned R8 and which is being redeveloped for 70 rental townhouses as approved by this zoning board in 2019. So the property, you'll see in the folder that I've handed out, there's some exhibits, including the tax plat that shows the various parcels with the railroad rights-of-way, which have been recently abandoned. There's an aerial photo that you'll see shows it's used largely for truck storage right now, and there's a street view photo of that as well. A copy of the board's decision on the northern portion, phase 1 of this property, is also enclosed for your reference. This is the continuation of that project. It's an additional 61 units. It'll have 121 parking spaces. It's heavily supported by the Brewers Hill neighbors, and there are letters of support in the file from the Brewers Hill neighbors for both the rezoning bill and the specific variances that are going to be required and for which we're applying today. And then you'll see a copy of the site plan in the file. And what we're applying for are variances related to the side yard setback where the project abuts the northern portion of the property, which, if I can demonstrate, are over here, and rear yard variances along the top here. The property is unique in what's driving the need for the variances because of its irregular shape. It's sort of a trapezoidal shape. It's composed of 4 lots that are being consolidated, and because of the Baltimore City Greenway Trail, which is proposed to be constructed as part of this project and will run through the site. And so the houses have to be sited in a way that allows the construction of the trail, which is something that has been the subject of extensive discussion with the planning department, as Mr. French knows. But we have finally arrived on a site plan that everybody likes and that satisfies the neighbors, it satisfies planning. And we are looking forward to moving forward with the rest of the Planning Commission review and approval process, as Mr. French indicated. So the variances are necessary in order to site the project in such a way as to allow the Greenway Trail to be constructed. The City Council, I will note, and the Planning Commission specifically, also found very compelling in the rezoning the fact that the trail would not be permitted based on the prior industrial zoning of the property, and that the rezoning would be necessary in order for the trail to be constructed. The last exhibit you'll see in the file is a sort of a broader view of where the trail will go. It's proposed to go all the way around the city, but in relevant part, it connects through Canton, and you can see phase 1 of the townhouse project, which is already constructed. Phase 2 is this white area here, and you can see the trail coming down behind the site, cutting across over through our site to Haven Street, and then it'll come down and connect through the Collective at Canton project, which is this large gray area that's showing is still under development at the bottom. So I have included in the file an outline that goes through the legal standards that the board is required to consider. As I mentioned, the property is unique because of its irregular shape and because of the constraints imposed by the Greenway Trail that need to be accommodated in laying out the site. And those constraints drive the practical difficulty that creates the need for the variances in this case. They're small setback variances. We meet the density requirements. We meet the parking requirements. It just is these side setback and rear setback variances that are required. These are conditions that are unique to this property. Again, they're due to the location of the trail, which is something that is unique. You know, the location of the trail through this property is a unique condition. And it's not something that is in the applicant's control and is not something that's done to increase the value or income potential. The site is being developed for fewer units than would be permitted by right based on its zoning. It would be allowed to have, I have 94 more units would be permitted if it was to be developed, for instance, as an apartment building, which it would be able to be done, but instead it's townhouses. The variances will not be injurious to the use and enjoyment of other properties in the immediate vicinity or substantially diminish or impair property values, as indicated by the letters of support from the Brewers Hill neighbors that are in the file. The variances are in harmony with the purpose and intent of the code. The project was approved by the Site Plan Review Committee this fall. It is consistent with the city's comprehensive master plan by creating new housing options in the city. There's no urban renewal plan at issue here. let's see, and it is not going to be detrimental or endanger the public health, security, general welfare, or morals, or be in any way contrary to the public interest. Again, the project is heavily supported by the Brewers Hill neighbors. So with that, I would request that the board approve the requested variances, subject to the condition that the city council bill to rezone the property to the R8 zoning district be approved by the city council, and of course, subject to Mr. French's suggested condition that the project obtain planning commission approval for the final development plan. I know that was a lot. I'll answer any questions.
I don't have any questions.
I don't have any questions.
I don't have any questions either.
I think Ms. Hecker
Did our job for us?
did our job for us. The lot is obviously unique. Most important to me is the issue of the practical difficulty related to the Greenway Trail. And that kind of sums it up for me. And I think we should impose those conditions.
For all the reasons that Ms. Hecker stated, which she went through the conditions, we can incorporate her argument into our fact finding. I'm a yes also for the reasons that Bill and Caroline have stated. Mr. Cunningham and Ms. Hecker.
Yeah, and
Mr. Cunningham.
I'm in favor of doing so as well. I understand the, concern with basing an approval, although it's very clearly subject to the approval of the new R8 zoning. We don't want to get carried away and have everybody come in if there's legislation down the road, but the recitation of where that legislation is, it appears to be fairly eminent. I'm comfortable granting
The fact that it's going to third readers.
going to approval, subject to that approval, and I think all the standards have been met for the variances as described by Ms. Hecker in her testimony and as echoed by my colleagues here.
I'm also in favor of approving the variances for the reasons stated prior.
Thank you all.
Thank you. Thanks for waiting. Yeah, that's helpful. That gives you finally calling case number 2022-441, 701 West Landale, East Wing Architects, the appellate. And you, sir, are?
My name is Evan Weigel of East Wing Architects.
Okay, and this is a request to alter the interior of the premises for use as neighborhood commercial and to establish 2 dwelling units. Is that
Yes, sir.
correct? Okay. Is there anyone here in opposition? No? Okay.
There was a case 414. I think somebody may have written the wrong number down. We were
You're not here in opposition,
This is my
sir?
client.
Okay, great. Okay.
All right.
We
staff and
originally
planning?
consent to talk it.
I'm sorry. We didn't have this gentleman sworn. I don't think we had him sworn.
You solemnly swear or affirm that the testimony you're about to give today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Okay, so there is one main thing being requested here, which is, and I need to double check this with the applicant, which is office under neighborhood commercial establishment. There is a letter of opposition in the file from the Upton Planning Committee, which is one of the reasons it's on the regular docket, and they think that the application is for retail goods, but the application says commercial office space, not retail goods. I think this property had been retail goods in the past. So maybe this can be clarified through some testimony here. There's also a request to use for 2 dwelling units. The last legal use of this property was as retail space on the ground floor with 2 dwelling units above. So in my opinion, I don't think they need variances to continue to use those 2 dwelling units because there's no change in. So in my opinion, I don't think they need variances for minimum lot area or off-street parking because those 2 dwelling units already existed in the last legal use of the premises. So really, what this request is for an office space under the neighborhood commercial establishment section of the code. In my opinion, planning's memo is different from me.
Thank you. The Planning Department reviewed this application. The application that was provided to the Planning Department stated it was to continue to use the premises as a neighborhood commercial establishment and a multifamily dwelling containing 2 dwelling units. There was no specification of exactly what the neighborhood commercial establishment use was going to be. If in fact this is being clarified to be office space, that has a considerable effect upon planning department's comments, I would say. The principal concern of the planning department, which has no objection to approval of the use as a multifamily dwelling containing 2 dwelling units, was that there not be neighborhood commercial establishment use of this property as a retail goods establishment with no alcoholic beverage sales. The community was extremely concerned about that and communicated that through the planning department, through our community planner. And on that basis, the department was going to recommend other non-retail, non-residential uses, such as an office or an art studio, instead of the retail goods establishment that used to be there on the first floor of this building. So on the basis of this request now being modified to state office use specifically of the first floor, the planning department would be in support of this application. Thank you.
Thank you, Mr. French. So tell us, if you can, more specifically what the office use will be for.
Could I bring my client up?
Sure. I don't know if he was sworn, so he'll have to be sworn as well.
Thank you. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Sir, would you rather sit at the table? Put a mic on? Okay.
How you doing?
Oh, sorry,
Stanley
fine.
Jones.
Mr. Jones?
Yes.
Okay, welcome. So what's
Well, we want to have 2 condos above the building, and at the bottom be offices, buildings. At the first floor, office. It used to be a liquor store, but we don't want it as a liquor store. We want to make like offices that can help the community, like different people come in, like a little school or things to help out the students in the evening.
Okay.
Like little offices and cubicles in the first floor, more than one. That's what we're trying to do.
All right.
Okay.
All right.
Yeah, there's a permit application that's been submitted for this project. We
Yes,
were
sir.
alerted to zoning after we had already submitted the permit application.
Okay.
And the plans clearly show an office space on the ground floor.
Okay.
Yeah.
Great. Any questions?
No.
All right. I think that's all we need to hear.
All right, thank you, I appreciate it.
Thank you very much.
Thanks so much. Okay.
Anybody want to run through the conditional
Well,
use
it's
factors?
pretty obvious it would not endanger the public health, safety, or welfare. It's not precluded by any other law, including urban renewal plans.
They gotta wait for a written one to come out anyway. Maybe they want a surprise.
It's not contrary to the public interest, and the authorization is in harmony with the purpose of the code, and that's enough for me.
Schultz, Prince?
Well, like I said, that's enough for me.
Okay. Sounds good. I'm a yes.
I'm a yes.
Based on the findings stated by Mr. Cunningham, I'm a yes.
Yeah, I don't believe that any negative externalities that would be associated with an office use at this location would be different than if it were anywhere else in the zoning district. So I'll approve the conditional use.
Okay. All right, we're off the record for today. Thanks so much.
That was kind of interesting, that.
Yeah, that's one word for it.